that'll be challenging.
Thanks for helping us today.
We're up to YouTube today.
Oh. All right, I'm gonna clean up my clothes.
me both. To my Wisconsin Eye friends. Are you live streaming? Color me happy.
And I'm still working on all the other chords.
Good morning, everybody. I think this is government, this is late for government, but early for journalism, right? I'm Annie Schwartz. I'm the Communications Director for the Department of Justice. We are so happy you could join us today. We're going to be live tweeting today, so if you're going to live tweet, our hashtag is #AG Schimel Summit. I probably could have come up with something more clever, but it's been a really long time since I wrote a headline and my cleverness has died. So, without further ado, going to bring up Attorney General Brad Schimel to welcome you and tell you a little bit about what we're going to do today. So, Attorney General Brad Schimel.
So I want to make sure you're all in the right place. This is Differential Equations 401. This is not your classroom, then please exit. I have no idea why so many of you would be interested in this topic. And I fear that some of you may have been misled. There is no free beer. So, sorry. Seriously, welcome. And thank you so much for coming today. This is a fantastic turnout. And hopefully we can do something meaningful today. Let's just get right to the elephant in the room. Messing with open government laws is like touching the third rail. I think that experience has been, well, it's been learned recently. And really this summit has been something that has been in the planning long before what happened just weeks ago. And it's because Wisconsin's laws on open government were written back in the late 1970s, passed in 1981, long before anyone envisioned email or tweeting or any of the other things, Skyping. We don't know whether a town board supervisor can appear at a meeting via Skype. We don't know the answer to that from our open meetings law. We don't know the limits to which the video captured on an officer's body camera are all public records. We don't know where we divide the line between the right to privacy of innocent citizens and the ability to get those records as part of what government does. So we have a lot of things to explore, and we're going to try to do some of that today. Now, I promised on the campaign trail and in my early time as Attorney General now that I was going to make open government a priority. And I also recognized that if I was going to make it a priority, I was going to have to take a look at our own house first, since I think the Department of Justice rightly should be an example for other government agencies statewide. And I started from two premises as our team began working on this. First was, we don't have anything to hide. I'm proud of the work we do at Department of Justice, and the more people learn about it, I think the better we look. So I start from that premise, and also from the premise that we shouldn't be searching for what we can redact or we can refuse to disclose, but rather what we must refuse to disclose, and then start from that premise. And I did find that we had room to improve. Whenever a new administration comes into an agency, there's always room to improve. There are always new things you can find. We had some very old pending requests that we've gotten cleaned up. Our average response times had some room for improvement, and we have and the team has done great work to improve those. I'll highlight some of those things in a moment. We established the Office of Open Government. We have centralized the process. Previously, if you wanted something from the Division of Criminal Investigation, they had a process over there. If you wanted it from CIB, they had a process. If you wanted it from the Fire Marshal, they had a process. All these different crime lab, you name it. We're now doing this through one central office, and I think that's going to make things long-term much more efficient and easier. We have implemented new workflow processes to track and fulfill public records requests at DOJ. We're sending out acknowledgement letters promptly. I think that's something that's very important to let a requester know. We got it. We got your request. We're working on it. And then we're going to log them electronically on over time and make sure we're keeping track of how quickly we're getting these responses out. And we've got a designated Assistant Attorney General who will monitor these things. A couple highlights since from the last 6 months here. We have closed 394 public records requests in the last 6 months, including 73 that came from previous years. We have decreased our response time on public records requests from an average of 58 days in 2014 to 17 days in 2015. We now respond over 5 times faster than we did in 2010. And in spite of this is all in spite of the fact that the number of requests is increasing rapidly. In 2014, there were 486 public records requests to the Department of Justice. We've had 397 in the first 6 months of 2015. So things are growing. This is growing all the time. We've made high-profile law enforcement investigation cases available online, particularly some of the officer-involved death cases, and that's really sped up access to those records once we're ready to release them. We filed an amicus brief in the New Richmond DPPA case supporting openness. Some coming attractions. I recognize that DOJ could and should take a more prevalent role in enforcing compliance. It's often very difficult for county DAs to take these cases on. They're busy, and they can be very difficult conflicts for them, especially in smaller counties. So I recognize a need for us to help out more on those, and we will. We'll attempt to mediate cases when we can, and when we cannot mediate them and get to a quick satisfactory result, we will take enforcement action. We're completing an update and overhaul of our online compliance guides, and we will be continuing the tradition of providing training sessions, and we're going to have a free training webinar this fall to get that kicked off. And we are drafting a written email retention policy for DOJ, another place where I hope that we can lead. So today, what are we going to try to accomplish? We're going to solve all the problems in the public records and open meetings realms. No. We're hoping that maybe today we can find some common ground. There might be some low-hanging fruit that if we can reach some consensus, that we might be able to go to the legislature with some changes they can make without having to worry about touching the third rail. We're looking at how we interpret the public records and open meeting laws in light of new technology. That's one of our goals today, to see if we can find ways to have our open government laws address those things more clearly. Hoping to create some cost efficiencies in government without sacrificing transparency, and identify areas where public records and open meetings laws need legislative modernization. We won't solve all that. We won't do all that today because this is too big a group. We can't. We're not going to delve into the details with this larger group, but we will follow up quickly with some additional meetings with some representatives from many different stakeholders and see if we can reach those consensus areas. And I look forward to being able to help our legislature do some things that make good sense and continue Wisconsin's very strong tradition of transparency in government. So thank you very much for being here, and I look forward to a fun day. And I hope that maybe we can get the air conditioning turned up a little higher. Is it warm in here? Yeah, okay. It's not just me. Thank you very much.
And more important, it's not just me, although I am 55 and I always think it's just me. Next, I want to introduce you to Ann Bensky. We know her as Andy at DOJ. She is an Assistant Attorney General. What I'd like to do instead of introducing everybody as one of the lawyers is to find some fun fact about them. And here's something I learned about Andy, is that she had a previous job coordinating media licensing and intellectual property permissions for Condé Nast publications and for Corbis Motions. So she has a Bachelor of Fine Arts in film writing. I like knowing that. And I want to introduce you to Andy Bensky. She is going to chat with you a little bit about the 101 overview of the records law. Andy.
So I see my PowerPoint on the computer, so at least I know what to say. Is the projector turned on? The public records law is not the only place where we experience technical difficulties. Is the PowerPoint showing?
Johnny, is that PowerPoint showing? No,
not yet. We'll give it just 1 minute. I want to thank everybody for coming. This is a very, very long room, so I apologize if I don't look all of you in the eye. And I want to thank the Attorney General for bringing us all together today. I must say that when I first heard that he was thinking of doing a public records and open government summit, I thought, yeah, right, that's never going to happen. But here we are today. AG Schimel is personally invested in open government. I have seen him talk about it and go to meetings. He's not just faking it, he really does care.
I'm dying.
Let there be PowerPoint.
I thought I was dying.
There I am. Okay, so I was asked to give a basic overview of the public records law, and I usually give this speech to people with a pretty limited knowledge of the public records law. So I got a list of the attendees, and I was looking down, and I said to myself, this group does not need an overview of the public records law. And I got a little bit concerned because I still have 15 minutes to fill. I don't have any party tricks, so here we are. We're gonna have an overview. But I've highlighted some broad concepts that are hopefully going to help us today as we think about some of these very complex issues that we are addressing. First of all, the public records and the open meetings laws have specific provisions that allow for the Attorney General to give information and advice about the laws to the public. This is very unusual. Chapter 165 of the Wisconsin statutes is the place that talks about the authority of the Attorney General, and the Assistant Attorneys General who give advice about open government to the public typically represent state agencies and the legislature and the governor and act as special prosecutors. So this law is actually very unusual and very special for the Attorney General's office. So I'm going to run down a couple of things of how we provide those services to the public. We do formal and informal opinions, write letters, and memoranda. And a lot of those are obviously available to the public. They're on the Attorney General's website, they're in the library, they are on the Wisconsin Freedom of Information Council's website. And even though those are not binding court opinions, they do give some information about how the Attorney General, this office with special expertise, is interpreting the law. We also have a lot of direct public interaction, and we have something called PROM. It's not the high school prom. It's the Public Records Open Meetings Hotline. This year we've handled 281 calls, and really we'll get everything from a local law enforcement agency wanting to know what they need to think about when they have a public records request for an investigation into a brutal sexual assault or murder. We also get questions from citizens who want to know if it's okay for their local school board to charge them $10,000 in location fees to get emails that they requested. So we really have a huge gamut of calls from a different variety of requesters. And each time we get a call, we try to return it within 24 or 48 hours. That does not always happen, but that's our goal. And it really does give the attorneys in our office a unique view into what's going on in the public and what the public cares about and what questions the public has. AG Schimel had mentioned that the office might be taking up more enforcement actions. We have the ability to do that. We write amicus briefs. We defend state agencies who are sued under the public records law, and there are about 15 to 20 cases per year. There are about 10 AAGs in our office with a special expertise in open government, and of course, as AG Schimel mentioned, we have our own public records request to shepherd through our agency. And one of the biggest areas is we have about $700,000 a year for adult criminal history information, and that is automated. And that's how we're able to respond to those. So the history of the public records law. The most important thing to know is that the idea of open government is not a new concept. It didn't come out in the 70s. There's a Market Law Review article I cited here. If you're really interested in this subject, it really is a good read. If you're not, it's a good way to help you fall asleep at night. But so this is a 1956, so read the article. It talks about this Jefferson County v. Besley case. It's an 1865 case where a county clerk wanted to be reimbursed $22 for wood to heat and light the circuit court clerk's office. This case went to the Supreme Court over $22, and little did they know that in 2015, it is just as hard to get reimbursed to $22 from the state. Beasley is an interesting case for several reasons, and it's actually very short, which is helpful. It mentions that the statutes require the clerk of the circuit court and other county offices to keep books and papers required to be kept in the office open for examination of any person. But what's remarkable about this case are a few very simple and obvious concepts that it talked about that are very important to us today. The court says that it would be simply absurd for the legislature to require county offices to be open to transact business, yet provide no heat or light in the buildings where the business is transacted. So this case stands for two important things. One, the cost of open government falls on government. And number two, if the law says that the government needs to give something to the public, we need to find a way to make it happen. Our predecessor statute is section 19.21. It was enacted in, I believe, 1917. It is another very short read, and it really gives broad brushstrokes of what became the public records law that was enacted in the early 80s. So in the late 1970s and early 80s, a lot of states overhauled their public records laws or created public records laws for the first time. And a lot of it is in response to Watergate, concerns about government accountability. But there's also a modernization of society going on at that time. In 1981, personal computers were on the horizon, but just barely. Most people didn't have them, and most people didn't transact business on them, but they were there. And with the advent of computers, we started creating more and more records. Fast forward to today, in 2015, my kids don't know the difference between a telephone and a camera, a radio and a computer, because they're all on the same tiny device that I look at all day long. Sometimes it feels like applying the public records law today is like trying to teach an old dog new tricks. So we're here today to try to learn some new tricks, I guess. So the cornerstone of the public records law, its heart and soul, is that nearly, and what every case starts with, almost every, oh, I'm on the wrong slide, pardon me. Let's just back up, talk about the public records law as it is right now provides access to records that exist. It does not provide, it's not a general records retention statute. That's in a different location of the statutes. And if you're interested in public records retention laws, go to the Public Records Board. I think Matt Blessing is here today. You can corner him and talk to him about that. So here's some information for the future. So here is our heart and soul of the public records law, our policy declaration. Nearly every case that talks about the public records law starts with this policy declaration. And I picked out the words that I thought were the most important. In a representative government, we must have an informed electorate. All persons are entitled to the greatest information regarding the affairs of government and the official acts of those officers and employees. This is an integral part of the routine duties and officers of employees, of public employees, and this goes back to the Besley case. There's a presumption of complete public access, and only in an exceptional case may access be denied. The cornerstone of the Sunshine Law is that any requester has a right to inspect any record, and our definition of a requester is extraordinarily broad. There's a little slide missing, so the next thing that we talk about is the definition of a record. The definition of a record is not quite as broad, and it may be one of those things that we need to talk about and think about. There's been litigation on drafts and notes, and what does it mean today for an authority to keep a record? If I have internet access, am I, as a public employee, keeping every single record that I have access to? If I have a special login that I can get to the Department of Administration or the Department of Corrections because I'm an AAG representing them, do I, as a representative of the Department of Justice, keep those records? In that, can you come to me and say, I want those records that you have access to that are really on a different agency's portal? So for those of you who think in pictures, here we are. Except as otherwise provided by law. There are some clouds, but anybody who has ever grown tomatoes in their backyard knows that clouds and rain are sometimes important. So too in the public records law. We don't want this. We want this. Briefly, there's some exceptions within the public records law in 19.36, also in 19.35, sub 1, sub AM. When people request records about themselves, there are specific exceptions that apply. The Wisconsin Public Records and Open Meetings Handbook gives a list of all the Wisconsin statutory exceptions. And that's a great place to go. We also have federal statutes to apply. Some of them are pretty easy to apply, like the confidentiality of medical records. Some are not, like the DPPA. We also have 19.356, where under very limited certain circumstances, a record subject is allowed to go to court and enjoin release of the records. This is a partial codification of the Woznicki case. So we have the public policy balancing test, and I think that's probably the biggest cloud that we have to deal with it. So what is it? It's what's the best thing for the public? It does not balance purely private interests against public interests, but sometimes those private interests may align with the public interest, and I gave some examples here. What factors should we consider? There was a recent Court of Appeals case, Ardell v. Milwaukee Board of School Directors. It was a somewhat controversial case in that the Court of Appeals said if you have information in front of you, you should consider it. You can and you should consider it. But that may be something that we should talk about more. We need to figure out who the requester is. Are we allowed to consider that? Are we allowed to consider what the records will be used for? Where will the records end up? Does it matter? Should we care? Why is the requester asking for the records? How the requester will use the records? If a company that is using all of the public records and selling them for profit on the back of government, should we allow that? Is that okay? Is that not okay? We don't have answers to all of these questions. Privacy concerns in the digital age. Private information being released to the public in 2015 is extraordinarily different than it was in 1982. We're going to talk about how to provide access, greater access, and who pays for it. Responding to public records requests should not disrupt the other essential government functions. So we need to find ways to make this happen without sacrificing transparency and without sacrificing the efficiency of the offices that need to transact important government business. One way of doing this is creating online repositories of information available to the public worldwide 24 hours a day, but there's a huge cost in creating that, and how are we going to pay for it, and who should pay for it? This is my "Can't We All Get Along" slide. I think that when I think about the public records law, I think it's a public trust doctrine for information. Governmental records in Wisconsin are an important public resource, and they're owned in common by Wisconsin citizens and held in trust by the governmental units that keep them. Governmental records belong to the people of the state, and a request is denied, the trustee is telling the owners that they can't have what belongs to them. So it's under this backdrop that we talk about all of the very complex issues we're here to talk about today. So thank you, everybody, for your attention.
Okay, get those raffle tickets out for, lost my head. Just to let all of you know, we're going to make the Attorney General available. I know a number of you had wanted some one-on-ones when we have a chance here today. We have the first break around 10:30, so if you would like to gather right outside this room, then we can make the Attorney General available for you, and you can ask him scary and bad questions. I'd like to bring up the Attorney General again. We are going to talk a little bit about protecting open government and public safety. Attorney General Schimel.
Well, the first session we're going to delve into today addresses changing technology and law enforcement. Dashboard cameras, body cameras. We have increased public scrutiny of everything law enforcement is doing now. We have evolving legislation like Wisconsin's cutting-edge officer-involved death legislation. And right now, law enforcement has no guidance. on how to handle these issues. There's nothing out there to tell them what to do. What must they redact to protect privacy? What if some of the things caught on those body cameras involve nudity, gruesome images, statements by sensitive crimes victims? What obligation do we have or responsibility do we have to keep some of that from the public purview? Or what do we have any authority at all to protect the public from seeing gruesome images? We grappled with the tragic death of Trooper Casper and in what things would be revealed, because there are some sections of video that cover parts of his death, or parts of when Tony Robinson was killed, parts of that too. And we've struggled with that. You know, where do we want those things to end up? Do we want those to end up on some skinhead's website somewhere and for entertainment value? So these are real serious questions for law enforcement to grapple with. What do they release? What don't they release? When officers go into an innocent person's home to talk with them, should video of the inside of that person's home become something in the public realm? Does anybody know where to find the answer to that right now? I don't think so. So we have some experts today to talk about that. James Friedman, he's the leader of the Insurance and Reinsurance Working Group and co-leader of the litigation team in the Madison office. He practices in civil litigation area with an emphasis on insurance coverage, insurance liquidation and guarantee fund work, media law, appellate litigation, intellectual property, and health care. He recently served as Wisconsin counsel for 14 multinational banks in the restructuring of the Ambac Assurance Corporation. Now, he is also he earned his undergraduate degree with high honors from Georgia Tech in electrical engineering in 1988, graduated with honors from the University of Wisconsin Law School, and received a Master of Public Affairs from the University of Wisconsin, both of those in 1992. Samuel Hall, Jr. is a shareholder at Crivello Carlson. He received his bachelor's degree and law degree from Marquette University. During law school, Sam was a St. Thomas More Scholar for 3 years and was a member of the Marquette Sports Law Review. His principal practice focuses on civil rights litigation, municipal law, and appellate practice. He has successfully defended many government officials, law enforcement officers, and municipalities in cases involving alleged civil rights violations. Jill Karofsky has been the executive director of the Wisconsin Department of Justice's Office of Crime Victim Services since 2011. And prior to her appointment, she was an assistant attorney general and was also, prior to that, a deputy district attorney in the Dane County District Attorney's Office. She is also an adjunct professor at the University of Wisconsin Law School and has taught trial advocacy and specialized courses dealing with victim rights. And Jeff Myers is president of WisPolitics.com, an online political and government news service in Madison that operates WisPolitics.com, WisBusiness.com, WisOpinion.com, and other news services. WisPolitics.com, the flagship news service, was launched in June of 2000. So could we please welcome them up to the table here and begin this interesting discussion.
Good morning, everyone. First of all, I'd like to thank the Attorney General for the introduction and thank Attorney General Schimel and his staff for organizing this event. Thank all of you for coming here. It's especially good to see so many friendly faces from local government. My role this morning is to more or less introduce the topic and to speak to you briefly from a law enforcement perspective on the open records implications of police body cameras. The vast majority of my practice involves working for and with law enforcement in a variety of contexts, mostly in civil rights cases. And from that experience, I can tell you that there's been an interesting shift in the opinions of law enforcement on the issue of body cameras. I remember 3 to 5 years ago when the technology was first being seen, that there was some reluctance from law enforcement to use body cameras, because I frankly think that officers didn't understand how the images could be used. But as more time has passed, I think law enforcement is starting to embrace it much more for a number of reasons. I think first, the officers are seeing that just about everyone else is recording what they're doing. So it's nice to have a recording that shows from their perspective and their point of view as to what's occurring. You know, and particularly in the past year or two, it's telling, I think, that the public scrutiny that law enforcement is receiving is starting to challenge the public's buy-in, the public's consent to policing. If you look at modern policing and you go all the way back to the Metropolitan Police Act of 1829, one of the key components was that if we're going to have a civilian police force, we need public buy-in. We need the public's consent to police. Law enforcement's trained that in the academy, and they, you know, fully understand that. And I think that they're starting to see that the use of these body cameras can help rebuild that public buy-in and reestablish the consent to police. I think, as we'll discuss more here, though, today, the use of body cameras is not exclusively, or strike that, the use of body cameras isn't without potential pitfalls. You know, there are a number of privacy issues, retention issues, and a number of other different concerns that we're going to discuss that implicate the effective use of the body cameras. To help illustrate that, what I'm hoping to do, if the technology works, is I've got 4 samples of video from police body cameras that I think can illustrate some of these points. And I'd like to take us through all 4 of them. You know, and I think the thing to keep in mind is I didn't get these videos through any special connections or special privileges. The videos that you're going to see are videos that were released by the police departments to the media. So if they're redacted, they were redacted when they came from the police department. If they're not redacted, and there are some that aren't redacted, and there's some gruesome images and some profanity, that was the way that they were released to the media. And I think it's going to present a good opportunity to have some discussion regarding it. Now, if the technology works, let me introduce each video. This first video was from a little bit less than a year ago. An Oklahoma Police Department responded to a scene of a wedding where a known convicted felon had been engaged in some sort of aggravated battery. What you're going to see in the video is that the police officer goes up to the suspect, asks to pat him down. In the course of patting him down, he takes off and starts running. At some point, the suspect stops because he drops something, picks it up, and you see the officer shoot and kill the suspect. 2 things to consider. First, right after the shooting, in the video screen, you're going to see an onlooker who is clearly distraught and not happy that this officer shot the suspect. You know, one of the things that I think we need to consider is, does that type of an individual have any entitlement to any privacy rights? I would posit no. You know, the person's in a public place. I don't think there's any expectation of privacy there, but others may disagree. But that's one thing to consider, particularly, you know, in light of his reaction to the officer and how distraught he was. And the other is to think about the images at the end with the body. There is no redaction, and, you know, this individual has just been shot dead. There's blood on the ground, and, you know, his family was obviously very distraught that this was released to the media. Is the audio on? Is the computer on? Okay, I'm sorry. I'm gonna go ahead and, I'll play this one without audio, and we'll see if we can get that fixed for the. So you see there, the suspect stops. From the video footage, I think it's difficult to see exactly what happens, but the suspect dropped his gun, picked it up, and as he picked it up, he pointed it in a direction towards the officer while he was running. So this onlooker is yelling and screaming at the officer, you know, how could you shoot him? Why did you shoot him? It was, you know, somebody affiliated with the wedding. You knew it was going to be simple, something that simple.
Get back!
Thank you.
Get back! 513 star to your miss. Suspect been shot. He's got a gun.
At this size and resolution, it doesn't come out, but there's a fair amount of blood in the water there.
Yeah.
And his face is not blurred out. It doesn't come across very clearly here, but at a smaller size, you can see that the face isn't clear. Many of the other presenters after me are going to take on some of these topics. Again, my goal here is just to introduce them so that you can see for yourself what exactly we're talking about. This next video is from a traffic stop in Las Vegas, and there ends up being an officer shot and the suspect shot in this traffic stop. There's no audio initially, but eventually you're going to hear audio, and you're going to hear a fair amount of profanity coming from the driver, which I think begs a question of, you know, in this type of a setting and with a driver, you know, should police before releasing videos be you know, redacting any of that audio? The other thing to keep in mind is, you know, we always talk about how rapidly evolving police events are. This, by definition, I think shows exactly that. We're going to try this again. The other thing, before the audio starts, I'll keep talking here. The other thing to keep in mind is that this camera on this officer is placed on his lapel. It's not placed on the glasses. It's generally two different places that the cameras are located. In the course of the stop, as the shooting occurs, you're going to see that that camera becomes dislodged from the officer's lapel, and so we miss a key part of it.
Because I went by the White House. No, you did not. I pulled you over because your tail light is out. That's why I pulled you over.
No, my brake light.
Your brake light.
Yeah,
Same
but I
thing.
still have two.
Oh, no, it doesn't matter. You have to have them on the opposite end. The top one is irrelevant.
They're just never gonna
The
fucking
top one is
feel well,
irrelevant.
are you?
Listen, why don't you fix it then? Why don't you do what you're supposed to do?
Because I'm in the middle of a fucking movie.
Okay, well then, it is not my problem. It is your problem. You need to fix it.
always my problem.
Listen, is this a right or a privilege to drive? It's a privilege, right? So don't take it out on me. Accept responsibility for what you're doing. All right?
I am
You're a grown man.
Yeah,
Then
and I'm done with it.
Then keep it down.
I'm done with it.
All right, let me see your driver's license, your registration, please. Do you have any weapons in the vehicle?
Yes, I do.
Where they at? All right, don't grab it.
Rifle's back there.
All right, come
No,
on,
I'm not going to fucking
Sir,
jail over
Sir,
there.
I'm not saying you're going to jail.
That's fucking ridiculous. You guys took my fucking gun yesterday. I got hit by a truck.
Who says you're going to jail?
I got hit by a truck yesterday. I told them my wife's taking off with my gun. They put me in
Who
handcuffs.
says you're going to jail?
That fucker in Enterprise.
Right now, are you talking to me?
No,
Did I say you're going to jail?
no.
Exactly. So why don't you give me the chance to talk to you to figure out what's going on without you getting all locked up?
I am riled up.
I
Because
understand.
I've been harassed nothing
I'm
but
not
the
harassing
last
you.
2 days.
Hey, well, that's not my fault.
I come down here, I get stopped, my wife hits me with the truck. I had to walk all the way from fucking Blue Diamond and Buffalo, all the way back. I flagged down the officer. He seen her hit me with the truck. What does he do? He gets out, I said, stop her. She hit me with the truck. She's leaving with my weapon. What does he do? He puts me in handcuffs.
All right, well, like I said, I wasn't there. I'm talking to you about a different situation, all right? Do me a favor, just step out really quick because I don't feel safe with your rifle in there.
No.
All right? Step out of the car, sir.
No.
Sir, I'm not going to ask you again. Step out
I'm
of the car.
going to shoot myself.
Do you have a gun?
Yeah.
Stop! Stop! No! 413! He's got a gun! Gun! Shit! Who's hit? I'm hit. Oh, my God! Where you hit at? Right here. Shit. Pressure. 444. Okay. You need a...
Okay, so you notice there that the redaction was used to cover the officer's face and the head wound. The officer survived that shooting. The suspect was shot as well, and he survived. This video shows and Attorney General Schimel hit on this in the introduction, is how do we handle videos inside of the home? And so we have a individual here who's in mental duress, who's cutting himself and or attempting suicide, and he flees the scene of a car accident and goes to a friend's house. So this is not his home. He flees to a friend's house, is in the home, has a knife, and he's eventually shot and killed by the officer. But the concern is, this home wouldn't ordinarily, the inside of this home wouldn't ordinarily be, the subject of any type of open records or frankly, even a search at the initial point that it goes in. The other thing to consider in this is, I spoke before about the difference between the body cameras on the glasses versus the lapel. Notice during the shooting that the hands of the officer holding the gun are directly in front of that lapel camera. And so there is a limited view of it.
He's not going to try to get out.
So why is
I'm worried about him cutting himself.
with a knife?
Yes.
Is he trying to right now?
I'm worried more
Come
about
here.
him.
Come out here. I guess the male's inside trying to cut himself with a knife. Have a seat here.
I'm just worried
Just
about
have a seat. Have a seat, please. Don't move.
Okay.
Eric! Coeur d'Alene Police Department. Have a seat like I told you to. Thank you. Eric! Coeur d'Alene Police Department. Come on out here, please. Eric, Coeur d'Alene Police Department. Please come out and talk to me. I need to get your insurance and everything else for that crash, please. We're going to be at Unit C, 1423. Eric, please come out and talk to me. Whatever you're considering doing, it's not worth it, man. It's just a crash. Coeur d'Alene Police Department, please come out and talk. Go ahead. You said there's not a back door to this place?
No.
Is there, can you get out any windows?
I don't think so, no. I don't think anybody possibly could. Maybe there's someone small.
Put the knife down now. Put it down. I'm serious. Put the knives down. I need you in this house right now. Put the knives. I will shoot you. Put the knife down. Put it down. Put it down. Put it down. I'm code 4. I'm code 4.
You didn't shoot him.
Get down.
Get out!
You
Get
did
back!
not shoot
Get
him.
down.
Get back!
Tell me you
Get
didn't shoot
back!
him.
All right, and we're going to skip the last video because I'm just going to try to speed things up and get on topic here. But the last video that I was going to show shows a heroin accident. So this individual had overdosed on heroin, got into a vehicle accident, and so there's video of the officer responding to the scene, but then there's also the video of the officer going to the emergency room to interview the individual who was in this accident. And so it begs the question of, you know, should we be releasing video footage showing an officer doing a custodial interview while a suspect is in a hospital gown, in a neck brace, you know, in the middle of a hospital room? And we don't have any clear direction, and in that case, the police released it. I want to conclude with just some final thoughts before turning it over to our other panelists. And what I want to just mention to this group is what I recommend to law enforcement departments as they begin exploring the use of body cameras. First, you know, and foremost, what I'm telling them is that, you know, number one, they should be making sure that they don't go cheap on the software and that they don't go cheap on the training. The officers need to have the ability to do these redactions, to blur faces, to edit the video, to cut it, and so on and so forth. I think some departments have not had that. The other thing is to build discretion within the policies. The law enforcement agencies that I work with routinely use confidential informants. They interview them. They always interview reluctant witnesses, and the officers need to have the ability to have some discretion to take the glasses off or to turn the video off if they have somebody who's not willing to talk to them or that they need to maintain confidentiality. The other thing is the length of the retention. I think this is getting cheaper as technology improves and everyone moves to the cloud. You know, but there's a real issue as to how long do we retain these videos. You know, I think the consensus has always been a relatively short period of time, but I work in the field of civil rights litigation. I have a 6-year statute of limitations before a federal civil rights lawsuit can be filed against my officers. You know, an example of this is I'm representing the city of Milwaukee in about 100 strip search cases where suspects have alleged that they were subject to strip searches in the street. And more than once I've had the federal judge tell me, well, geez, we wouldn't be here if there were only body cameras on these officers. And while that sounds great, I don't know if it's true. You know, these allegations didn't come about until 2, 3, sometimes longer, 2 or 3 years, sometimes even longer, after the stop and after the search. If it's a routine traffic stop and a routine drug arrest, are we really going to be saving that video for 2, 3, 4, or 6 years? I am a strong proponent of retaining the video for 6 years as long as that's our statute of limitations for civil rights cases. And if we don't like 6 years, then we should be working with the legislature to decrease that statute of limitation. The other thing is to, and I guess the final thing, is to consider starting with a pilot program. As the handout in your folders indicates, this is not a one-size-fit-all type of proposition. The goal in any body camera program is going to be to implement the program without impacting other policies to the extent that we can do that. And so because every department operates differently, I think it's important to start with certain officers, perhaps on certain shifts, see how those officers utilize the cameras within a pilot program before going full steam ahead into a department-wide program. So with that, I'm going to turn it over to our other presenters, and I think we're going to have a Q&A at the end, or you can certainly find me on a break. Thank you.
Good morning. I'm James Friedman from the law firm of Godfrey & Kahn. I work here in the Madison office. I'm not going to talk about insurance today. I have practiced for about 22 years at Godfrey & Kahn, and my practice has had a component of media law, including public access, since day one. It continues to till today. I'm also a member of the Wisconsin Newspaper Association Foundation Board of Directors. So I want to make sure that it's clear that my practice in this area tends to be as an advocate for the news media. That said, after listening to Sam and certainly to the Attorney General, I don't know that there's going to be a world of disagreement between us. I think our positions probably are not dramatically opposed. The other point that I'll make before I jump in is to let you know that I met Jill Karofsky, who will speak next, on our first day of law school in 1989. So for those of you who can't get the Attorney General's attention during the breaks, if you want stories about Jill, I have plenty. Unfortunately, Jill has just as many about me, so maybe we should avoid that entirely. It really is my pleasure to be here today, and I want to thank Attorney General Schimel for the invitation. But more than that, I want to thank him for really since the campaign, since day one in office, taking such an interest in open government and a leadership role in the topic. It's been pretty clear to me since he took office that his door is open for those interested in this subject, and certainly this summit demonstrates his commitment to open government and his willingness to listen to the constituents on these very important topics. With all due respect to the Attorney General and to others who I'm sure will probably advocate for more significant changes, my basic premise today is that the Wisconsin Open Records Law works quite well. With fairly minimal legislative amendments, with interpretations by the courts over the decades, it has been flexible enough to handle changing technologies, including changes in the ways that people communicate, in the form of records, changes in journalistic techniques that I'm sure Jeff will get into, and changes in law enforcement methods and technology. And so I have a strong preference, which obviously became stronger with the concerns that were raised during the recent budget process, that we not make massive overhauls to the open records law. I think it's working well. While there certainly are some possible tweaks, updates, clarifications that could be helpful, I think we should recognize that it's worked pretty well, and hopefully will continue to do so. And the reason why the law has worked so well is because of certain key provisions that have permitted flexibility and let it maintain its vibrancy and relevance over the years. Andy suggested that the definition of record maybe is not as broad as we need. I would suggest it's awfully broad. She put it up on the board, or at least parts of it before. It's in your materials, but it's in 19.32 sub 2, and it says record means any material on which written, drawn, printed, spoken, visual, or electromagnetic information or electronically generated or stored data is recorded or preserved regardless of physical form or characteristics. So I would suggest that's awfully broad. And if you look at the case law, if you look at Attorney General opinions, there's not much out there about whether some physical form is a record. I think we all recognize, the custodians recognize that regardless of the form, if it contains government information and if it is recorded somehow, it is in fact a record. So that definition has served us quite well up to this point. Next, and this is the one where I think it's more a matter of education than it is changing in the law. I believe our very, very strong presumption of access in section 19.31 in the Declaration of Policy in the Open Records Law, which again, Andy read from and was on the board on the screens before, along with the court-created common law balancing test, has served us very well. And as Andy noted, the balancing test balances public interests, although oftentimes they will overlap with private interests. But the result of this combination of the strong presumption of access with the balancing test has resulted in our law working quite well. And what happens is, regardless of the form of the record and regardless of the information contained in it, the custodian is mandated, always has to perform the balancing test, except in those limited circumstances where the legislature or courts have said, you know, a record is always open or is always closed. And so, while we don't always necessarily agree with the determination on the balancing test, I believe that's more a matter of education of custodians rather than a need to change the law, because the balancing test with the presumption have worked very well. Third, a tool that has not been discussed in great detail yet is, again, a mandate from the legislature that custodians look through records and redact that information that should be confidential and provide the information that should be public. That's in section 19.36 sub 6. So this is not a discretionary tool for the custodians. Every custodian has an obligation to consider whether redaction is necessary and appropriate. And again, the concerns that we've started to hear and will undoubtedly hear from speakers throughout the day about new types of records and information in records which maybe could be more graphic, for example, than in the past, those concerns can be dealt with through a combination of the balancing test and redaction. And then finally, again, which Andy highlighted quite well earlier, we have this great statute that gives the Attorney General the right, and citizens the right, to ask the Attorney General to opine on matters of open government. And the bottom line is this helps avoid conflicts, helps avoid lawsuits. I don't think I've ever seen a situation where one of the parties went to the Attorney General, got an opinion, and that both sides did not accept that opinion and move forward. And so you get a third party who's expert in this area looking at controversial topics, giving the rationale on why he comes out in a certain way, and again the parties accept that, and it makes people feel better about the process and feel like the result has some weight behind it. So the result of these, particularly these 4 tools in the open records law, is that the current state of the law is flexible enough to address concerns raised by new law enforcement methodologies and technologies. And I think that plays out with respect to certain types of records. Sam focused on body cam videos, and I'll do the same. I think we agree about most of body cam videos in the process and whether they're subject to open records laws. I'm a big fan of them. It sounds like Sam is as well. 99.99% of the time, I think they're going to be helpful for the law enforcement officers because it will give the public the chance to see that they're doing their jobs appropriately. It helps jurisdictions that have had them for a while, have seen it actually helps bring down the number of complaints based on police conduct. You don't get as many frivolous complaints because the person knows it was being recorded. There was no strip search, to use Sam's example. So in those circumstances, they're very, very useful. And I believe that body cam videos, in many circumstances can ease the tensions and the problems that we've seen recently, both locally and nationally, with respect to law enforcement use of deadly force. If we actually see what happened, it's much less likely we're going to have the various problems that we've encountered. So I'm a big fan of police body cam videos. One thing to keep in mind is it's not as new of a concept as we might think. Dashboard cameras have been around for several years. Law enforcement officers, here and elsewhere have been using those for a long time. They've worked very well. So it's another step towards openness, towards transparency with law enforcement actions, but it's not a dramatic step. And I don't think, again, that the law needs to make dramatic changes to adapt to it. I've put in your materials, and I want to thank Johnny for my last second request he was able to handle. The Media Law Resource Center, which is a trade association of media entities and attorneys who represent them, has put together a model policy on police body cam video recordings. And what I think is really interesting is that point number 1 is that most existing open records laws, can handle them, that you don't need dramatic changes to state open records laws to deal with these videos. Another thing I want everyone to keep in mind, and those of you who are in law enforcement or prosecutors or news media members who have covered the police and the courts, recognize that our courts have said that under the balancing test, law enforcement can keep confidential investigative materials if they reasonably believe that by releasing them it may hinder the investigation. And so the reporters in the room recognize that you don't usually get that information during the course of the investigation. You get the basic things, but you don't get all of the witness interviews, at least without substantial redactions. You certainly don't get confidential informant information because there's a specific statute on that. And so police body cam videos really will just be another piece of the investigative file. There are going to be times where our courts have said, they always should be available, maybe with redaction, but they should always be available. And for example, in the Areola case, the court said that when the police use deadly force, then the public has a right to know the facts behind that. And so I think in cases where lethal force has been used, the presumption is going to plainly, very clearly weigh in favor of access by the public. When the police conduct took place, out in the open, in a public area, in a public forum, again, I think Sam made the same comment, that's generally going to be available to the public. Again, redaction may take care of, concerns about privacy of third parties in the area. But those, generally the courts have said those things are going to be open. People could have seen them if any, passerby could have seen them. Sam mentioned briefly the cost of retention of the records, and his point's a good one. Right, if you're worried about having some kind of a drive holding all of these 24/7 videos of every officer in your police force, certainly that could get expensive. But a couple things. One, there are now cloud-based solutions that are much, much cheaper. The price keeps coming down. In the MLRC materials, it notes that at least one jurisdiction figured out that you can use YouTube. There's private places on YouTube that you can put things for free, essentially. And there probably will be better solutions in the future. The MLRC recommends, and I think Sam noted that most jurisdictions go the same direction, very short retention periods. The concept is if there's not a request for the information and there's not an investigation based on the video, that you only need to retain videos for a matter of weeks or maybe months, not years. Sam's point is a good one on civil rights cases, and I think there are a variety of ways to deal with that. You may have to use some resources to kind of sift through what is clearly innocuous versus those circumstances where there was in fact an arrest or there was some kind of a stop that could lead to litigation down the road. I don't think it means you keep everything, but maybe you keep a little broader swath of video. But again, the technology is at a point now and will continue to get move towards the place where cost is not an issue. The same is true with redaction. I know there have been concerns expressed about difficulty and costs of redacting video. I don't mean to be flippant, but the reality is that if I handed my 15-year-old and probably my 13-year-old a video and said keep X, Y, and Z and get rid of A, B, and C in a matter of minutes, either one of them could do that. So I don't think cost of redaction should really get in the way of public access to police body cam videos. It has not been mentioned yet, although I'm confident Jill will raise it, so I'm going to preempt Jill's point on this one. There have been concerns expressed about releasing 911 tapes, and there's a lot of ways to deal with that. The bottom line is I think the public has a right to the information contained in a 911 tape. I think the majority of those tapes probably can be released with minimal either redaction or using technology to make the voice non-recognizable. Some states have said we're not going to give you the tapes. Those states, though, give the transcripts instead. I would think in most circumstances, members of the public or the news media would probably be fine with the transcripts. Some of the broadcast media might not like to hear that because obviously it's more compelling if you're hearing a voice. But again, with the use of technology, we can get around those issues. But I don't think we should be changing the law on 911 tapes, again, much like police videos. I will note there are some areas of the open records law that could probably use either some clarification or a more definitive statement. I don't think it's worth kind of opening up the can of worms necessarily, but if we go down that path, there are some records that always should be public, and I think our courts have made that clear, and custodians should understand this, but the problem is they don't always get it, and if it's not as clear in the law, sometimes we have fights about some basic things. One example would be, and a lot of these have to do with police records and prosecutorial records. So arrest records, our Supreme Court many years ago in the Breyer case said, this is not a police state. This is not the Soviet Union. We do not have secret arrests. That when someone is arrested, the public has a right to know who was arrested, why they were arrested, when, where, the basics, and they have a right to know that right away. We can't detain people for days or weeks on end without telling the public. And we have had issues with that. And so to the extent that we're going to open up the law, maybe we should just make it very clear and, put it in the statutes. Arrest records are always open, period. Minnesota has, rather than a balancing test, has more of a laundry list of what's available and what's not available, and they have a section on arrest records, and here's what you get. The same is true for incident reports. Generally speaking, I think custodians understand those are open, but we have had issues on whether they're open or what information is available. And again, we could look at Minnesota as a guide, and I hate to do that. I mean, I'm not a Minnesota fan at all. Hate the Vikings, hate the Gophers. My in-laws are there. Don't want to go there, but their laundry lists for certain types of records, in particular law enforcement records, seem to work very well and provide some clarity. So if we're going to do anything, those are some areas that we might want to take a look at. So in conclusion, after 22 years of practicing in this area, I think we've got a good open records law. Our legislature did a nice job several decades ago, and I don't want to screw it up, but we could probably make some small changes to improve it. Thanks a lot.
James's in-laws are on the phone. That's a direct feed to Minneapolis, right? Good morning. My name is Jill Karofsky. I'm the Executive Director of the Office of Crime Victim Services. I'd like to thank the Attorney General for three things. Number one, for appointing me to this position when he became Attorney General in January. He continued my appointment. The second is for having an open government summit like this. This is a fabulous turnout. And last but not least, he arranged the batting order and he put me behind James Friedman, which means I get to react to some of the things that James said. If you think about all the attorneys that we have here, and I know that there are a lot in the room, in the criminal justice system, the defendants are represented, the media is represented, the law enforcement is represented, not always in the criminal case, but if there's a civil case. The state is represented by either the Attorney General's office or the DA's office. There's one group of people who are routinely not represented, and those are victims of crime. And when we think about the rights that we give criminal defendants, and we should, and we give them their Miranda warnings, I often think that maybe what we ought to do is give victims Miranda warnings or some sort of warnings. And I think they would sound something like this. You have a right to remain silent and not report this crime. Reporting it may or may not make you and your family safer. I don't know. If you do report, everything you say will absolutely be used against you in court. In fact, anything you've ever said, done, worn, or drank will most definitely be used against you should you testify in court. I should mention that courtrooms are open to the public, so everyone else will know the details of your life, including any counseling you may have received before, during, or after your assault. And when I say everyone else, I mean everyone else for all time. Thanks to the internet, all of your past, present, and future partners, landlords, employers, friends, neighbors, and acquaintances may get to know every detail about you and your life. Also, before I forget, your medical records are also fair game. Of course, this assumes your case will be fully investigated and charged. You do not have a right for your case to be charged in a criminal court. And unfortunately, we have a crisis of prosecution in Wisconsin. Our DA's offices are severely understaffed, making it less likely that charges will be brought against your perpetrator. You have absolutely no right to an attorney and don't even get the thought in your head that one might be appointed for you. You also don't have the right to have an attorney, an advocate, or anyone else present while you are being interviewed. You may decide at any time to exercise these rights, but the longer you wait to report this crime, the less likely anybody is ever going to believe you are actually a crime victim. There's a researcher who actually went to Duke University, which the Attorney General failed to mention to all of you that I went to, so I'm just going to do it myself. Go Duke. I was at the game in April. It was awesome. Anyhow, David Lisak got his, he'll never forget again. David Lisak is his name, and he got his PhD at Duke, and then he went up to UMass Boston, and he researched sexual assault perpetrators for years and years and years. And he came to the conclusion that when a sexual assault victim makes a report to law enforcement, he calls that a precious event. It is so special, and it doesn't happen very often. And it doesn't happen for so many, many reasons. There's one case in this state that has gone to the Supreme Court that deals with victims' rights, and it was decided in 2005 by the Wisconsin Supreme Court. The name of the case is Schilling versus the Crime Victims' Rights Board. And in that case, the Wisconsin Supreme Court said the following: justice requires that all who are engaged in the prosecution of crimes make every effort possible to minimize further suffering by crime victims. And suffering is right, because those who find themselves caught in the web of the criminal justice system suffer innumerable and unimaginable indignities. And when you talk to crime victims, as I have spent most of my career doing, they will tell you that the greatest indignity for most of them is the invasion of their own personal privacy. Few are as profound as the invasion of privacy. And that invasion, of course, has grown exponentially because of the internet. And because once something becomes on the internet, it's there forever. The internet does not forget. Victims often have this feeling of helplessness. They feel like they've lost control of the situation when they became a victim. And for them to continue to lose control during the pendency of a criminal proceeding or whatever happens after that is devastating for many of them. It's not unusual for victims not to tell their family and their friends what happened to them. So for that information to suddenly be made public is unbelievable. I know of one instance of a woman who was sexually assaulted in Milwaukee, and she didn't tell anyone. She called 911, and she reported the assault on 911, and when she was reporting it, she gave her name. The 911 tape was on the news, and a couple days later, her neighbor came and knocked on her door and said, "Oh my God, I didn't know that you were a victim of sexual assault." The fear and humiliation that victims feel is really palpable, and the people who really benefit from those feelings of vulnerability are perpetrators. Perpetrators will often threaten victims with more violence if they report the crime. And victims have every reason in the world to believe that that retaliation threat is real. So when we reveal something about victims, about their identities, about the crime that was committed against them, and that is later disclosed, victims are even more fearful because they think something else is going to happen to them. So when we talk about public safety, every single time a victim or a witness decides not to come forward and report a crime, when they decide they're better off not reporting, as many of them do, that allows perpetrators to strike again and again and again. And our whole criminal justice system depends on witnesses and victims coming forward. It is a rarity for law enforcement to actually see someone commit a crime, unless you're speeding on the Beltline, okay? Right? They don't usually witness the crimes. We need victims and we need witnesses. We need members of our public to come forward. And the criminal justice system crumbles without people being willing to do that. Victims read the news, they watch the news, they have access to the internet, and they know that it is not unusual for for other victims' identities and houses and locations and families and inside of their houses to later end up in a place where everyone can see it for all time. They know that other victims' identities have been revealed and that their privacy has been invaded. And for this reason, many people do not report crime. Now, the Wisconsin Constitution and the statutes have a number of provisions that protect crime victims. Okay, starting out with in section 950.01, it's the beginning part. The Crime Victims' Rights Statute is chapter 950. And chapter 950 starts with a part of the statute that talks about why the legislator passed the law in the first place. And part of that statute says that the legislature recognizes the civic and moral duty of victims to fully and voluntarily cooperate with law enforcement and the importance of such cooperation to the well-being of our criminal justice system. So that's just what I said. If they don't come forward, we don't solve crimes. There's a constitutional right to privacy that victims have. Article 1, Section 9M of the Wisconsin Constitution says the state shall treat crime victims with fairness, dignity, and respect for their privacy. 950.04 sub 1V says that victims have the right to be treated with fairness, dignity, and respect for their privacy. Again, mirroring the language of the Constitution. And last but not least, in chapter 950, at section 950.005 sub 1, the legislature actually talks to the media. And it says, the legislature urges the news media to use restraint in revealing the identity of child victims or witnesses, especially in sensitive cases. I will tell you, for a victim of crime, their crime is sensitive. Their crime is the sensitive crime. Just the beginning of this month, a mere 29 days ago, we have a new rule in Wisconsin passed by the Wisconsin Supreme Court. It appears in our statutes, it's 809.86. And after working for years with the Judicial Council, with the Supreme Court, some of us were allowed to go there and testify, and they put a new rule into effect so that when there are appellate briefs filed in the Supreme Court, they may not name crime victims. Appellate briefs describing victims' names must identify a victim by one or more initials or other appropriate pseudonym or designation. And the Supreme Court said that by enacting this rule, the Supreme Court intends to better protect the privacy and dignity interests of crime victims. And at the Department of Justice a few years ago, we stopped putting victims' names in press releases when we sent press releases out about criminal complaints that were filed. We're also trying to use more pseudonyms in criminal complaints so that we're not identifying victims flat out. And as the Attorney General and a couple other people mentioned, we're doing a lot of training when it comes to open records, and there's always a component of the open record training. I know Andy does it, and I see Mary Burke here. Hi, Mary. She took the victim privacy very, very seriously. So while I don't want to stand up here and say that I'm against open records law, because I'm certainly not, and I absolutely recognize the need to disclose these records so that all of us are able to monitor our government. And we want to do that because it makes us safer. It makes our government better. But disclosing the identities of crime victims doesn't do that. It actually makes us less safe. So by increasing the chances for allowing victims to maintain some confidentiality and privacy during the criminal justice process and for years into the future, we decrease their sense of victimization, re-victimization through surprise, embarrassment, terror, and humiliation. We allow victims to begin healing. We make every effort to minimize the suffering of crime victims, as the Supreme Court has told us to do. And we make Wisconsin safer for all of us. I just would circle back to what Andy said, and she talked about in her slide about the exceptional case. And I would say that most definitely when you're thinking about looking at the statutes or making changes or thinking about how to interpret things, that the victims and their identities absolutely fit into that category. Thank you.
Hi, everybody. I'm Jeff Maris from WisPolitics.com. I'm not representing all media here, but I think represent a lot of what media think. I'll echo a lot of what James said, but try not to be repetitive. I think it bears repeating what the preamble of the current open records law says. Again, shall be construed in every instance with a presumption of complete public access consistent with the conduct of governmental business. The denial of public access generally is contrary to the public interest, and only in an exceptional case may access be denied. Now, you heard Jill talk about what that exceptional case may be. I don't think most media would disagree with that. Certainly, sometimes things get out, but and sometimes because of media. But I don't think that in general media disagree that victims should be unnecessarily identified. But that preamble is very important. I mean, I think it rules whatever discussion we should have here today, whether it's on the criminal justice front or the open government front. So I disagree with the presumption that the state open records law needs to be rewritten or needs to be overhauled. Maybe it needs to be tweaked a little bit, but it's proven to be very flexible. If you actually read it, it's written and it holds up very well despite all the new electronic mediums that have emerged. The law's focus is about access to public records, not how they're disseminated, not how they're publicized. So, you know, the methods of dissemination may change, but, you know, the access shouldn't. So don't blame the messenger here. You know, to that note, sensational cases always garner sensational coverage. We can go back to the Lindbergh kidnapping, you know, to know that. It just is the way media work. And so with or without open records, that stuff will come out. So the 911 call, the video from the trooper's car, body cameras, they should remain as open records. And, you know, it's okay to have judicious redacting. I think that's generally accepted by media and the public. But shielding major parts of the story are not, because they eventually will come out before trial or in trial or at some point. So those things will just eventually happen. Open records, another point, open records are not just for the news media. I think, you know, yeah, you know, James is a media lawyer and I'm in media, but they're not for media only. They're a window into government and public officials' behavior for everybody. You know, we have the resources to do more open records requests and, you know, the lobby for preserving of the open records access. But the citizens have the same standing. The open records law does not talk about media. It talks about an informed electorate, an informed public. So if you don't like something that's going on in government or the criminal justice system, you can investigate it on your own through the open records process. That may be certainly uncomfortable, annoying, sometimes embarrassing to public officials, but it ensures transparency. And then as we, you know, I think the Attorney General called it the elephant in the room. Yeah, you know, since this was in the planning, there was a very controversial amendment, a budget amendment, but the outrage against that was not a liberal conservative thing. In fact, you know, it was across the political spectrum and it was rapid, and that's why it got pulled. Now to, I think, two things that haven't really, we haven't really talked too much about, but do impact on media coverage of open records in the criminal justice system. CCAP, or the Wisconsin Circuit Court Access. I mean, there have been efforts to rein in CCAP ever since it went operational in 1999, but the access has not been limited because, frankly, CCAP is very popular. It's not popular with prying media, okay, but citizens and businesses use it all the time. There have been charges that some businesses, you know, or employers or landlords are overusing it, wrongly denying jobs or apartments to people because of past offenses or past charges. But I think the the examples of that are fairly limited. The user groups say, they're using it appropriately. Some media groups, open records protection groups say, well, maybe there could be a law saying let's require those who deny an applicant to say why that the CCAP record was the reason for this. I think that's a debating point. There is also a movement to give nonviolent young offenders a second chance, an ability to expunge a record in exchange for good behavior or entering a certain program, and that's gaining steam around the country. There's been some proposals in the legislature to do that. I think that's another debating point, but that's a tweak. That's not rewriting the law. Again, the open records law, as James said, has worked pretty darn well. So, in terms of CCAP, it just makes it easier to get those public records. You can go down to the courthouse and get them. You could always do that. So it makes it easier to get them. Well, ease of access to public records is certainly in the spirit of the open records law. Now, the other issue that's come up is DPPA, which stands for the Federal Drivers Privacy Protection Act of 1994. Some people are trying to use the DPPA to get around the state open records law. But the Newspaper Association, I'm also on the foundation board with James, so he wrote me into this, so he's to blame. The Newspaper Association and other open records advocates are very involved in a key case. It's now before the state Supreme Court, New Richmond News versus City of New Richmond. Now, there was a very positive decision in a local court. The previous Attorney General, J.B. Van Hollen, issued a very favorable decision. It's now before the state Supreme Court. Essentially, if it has to do with public safety, then those records should be open. I don't think many of us can disagree with that concept. So, in conclusion, before we get to the questions, the state open records law has evolved since its writing through decisions by the court and the Attorney General. By and large, every decision by a court or an Attorney General is not perfect, but we've been moving along, and the law has been largely preserved. If nothing else, it should be strengthened, or there should be more education, certainly for local holders of the records. Things like this certainly help, but more education for all the custodians would certainly help. And the common law balancing test, some have said that's really expensive. Yes, sure, going to court's always expensive. James earns a good fee. He should. He's a good lawyer. But, again, you rewrite the law and toss the balancing test, the common law balancing test, that's worked so well. I think you have to think long and hard before you toss something that's working. So, again, we must be very cautious, be very skeptical, must review any proposed change carefully to assure that these changes don't hinder, as that law's preamble said, the presumption of complete public access. Okay, thank you very much.
Thank you very much, all of you, for that interesting examination of the challenges that maybe we do or do not face. I have a few questions that hopefully can generate some more discussion here. When an individual is caught on video by an officer's body camera, it's unlikely that they've been asked whether they consent to be videoed. And let's use the example of a bystander who doesn't have any particular involvement in the crime. Should that individual have some right to object to the release of the video of them doing whatever it was that is captured by law enforcement? Let's presume they're not a criminal defendant. is there some room for the statutes to address that?
The redaction policy is in there, is it not? And could they not blur the person's face or redact that segment of the video if it weren't deemed to, I mean, the custodian, as James pointed out, has that ability.
Well, maybe I'll let Sam ask this question.
Well, I think that from my experience when I've confronted this is that, yes, the custodian could redact it, but in some circumstances, maybe most, I think there would be pushback. I mean, if we take somebody that say comes onto a crime scene and is screaming and yelling, maybe saying something substantive, and we, black out or we edit out that portion of the video, I can think of scenarios where folks in the media or other requesters would object to that. So I think that from my standpoint, I think what happens outside in public is weighted differently from what happens inside of a home or something along those lines. I think the video that we saw earlier that shows the officer going into a home and confronting somebody, I think that if any situation presents an extraordinary case, I think that's it. Now, when you're outside in public, I could see folks from the media or other requesters opposing any efforts to redact that.
Yeah, I think I generally agree with what Sam just said. If this is happening, outside in a public place, in a public forum, there really is no expectation of privacy. You or I could walk up with our, not cameras, probably phones, and take a picture, a video of someone. If they don't want to be photographed or videotaped, they can certainly leave. But there's no expectation of privacy written into, state or federal law in public places, public fora. But I also agree with Sam that once you enter someone's private home, the balance changes, the interests do change. But I think it's a matter of education of the custodians. It's a matter of taking advantage of the tools that are in the law right now, the balancing test, and as Jeff mentioned, the mandate to review records for redaction. And so with respect to that particular scenario, I do think the balance is going to be different than a video of an arrest, for example, outside in a public area where there happen to be witnesses to that arrest.
But then my question then is, why doesn't the law already provide that? I mean, we have the balancing test, and my experience with that is that, oftentimes we're going to get into litigation, which, local government is, frankly, they don't have the money to continue to litigate these things. So why doesn't the law, are we going to really sit back and wait for the courts to address these new public records that are being created off of cameras? Or, shouldn't we kind of cut to the chase and say, if we're coming to a consensus to say that, something that happens in public is different than something that's recorded inside of a home, why isn't that somehow being codified so that we don't have to go through, litigation?
I appreciate the suggestion that Attorney General opinions and court opinions can address whether someone properly applied the balancing test, but I think to Sam's point, is that really fair to leave law enforcement agencies to make that, to try to predict what the reaction is going to be? Don't we owe them some prospective legislative advice on how to handle this?
Well, I'm the only non-attorney up here, so I don't write law, and we only second-guess people who write the laws. But, a law sets parameters. It can't anticipate every single case. So I think that what the balancing test has done over the years, from what I've seen and what I've been told, is that it allows that case-by-case examination, because every case isn't the same. You start trying to anticipate every case in law, in the law, in the statute, there's always going to be something that's not anticipated. So, I think that, again, the balancing test, I think, has served, by and large, there are exceptions, that by and large has served us very well. So we're going to junk it and try to laundry list everything. I think you're going to miss something on the laundry list.
I tend to agree with Jeff. I think the law provides the flexibility that custodians need. And while as I mentioned in my remarks, there are areas where the records are defined enough that a laundry list might be helpful. I don't think that's going to be the case with respect to a police body cam video that's videotaping incidents, arrests, etc. We've got some parameters, and as I noted, and certainly law enforcement in Wisconsin takes advantage of this, the courts have said that investigative records, to the extent that their release may hinder the investigation, may be kept confidential. And I think if you talk to the reporters in the room, they recognize that they're not getting most of the investigative records, at least during the pendency of the investigation. On the flip side, I think if there is a use of deadly force with respect to the arrest, then our court got it right when they said, boy, we have a right to know when the police actually use the ultimate tool at their disposal. So I think there are parameters out there right now. I think it would be impossible, and we'd probably lead to more problems than solutions if we try to say, okay, if it's a police body cam video, then if it's outside, you get it. If it's inside, you don't. Unless there's lethal force, then you do, but then you get to redact this, but you don't get to redact that. It should be a case-by-case decision. We should trust the custodians, the law enforcement officers, the prosecutors responsible for the records to exercise their discretion. They do have quite a bit of guidance out there already from the courts and the Attorney General, and can seek additional guidance with respect to individual requests very easily. So I agree with Jeff that while there are areas where laundry lists work, I don't think some of these new technologies are those areas.
I'm just going to disagree with this. There's zero guidance for law enforcement right now dealing with body cameras. We're just getting started with this, and I think while we can trust local records custodians, we're entering a new frontier here where they have nothing to go off of. Turning to another point, it's clear while there's an ongoing investigation, these materials would be confidential and would be kept out of the public, but that's only half the battle. Once the investigation is over, or once a criminal case is brought to a conclusion, these records are released, and we lose that basis to do it. I'm not suggesting that a laundry list is going to cover everything. We know that it can't. We know that officers see both the best and the worst that society has to offer, and we can't predict everything. But it seems to me that much of what law enforcement does is fairly predictable. We know that they're going to make traffic stops. We know they're going to conduct searches. We know that they're going to go into homes. We know that they're going to make arrests. Some guidance from the legislature, I think, would be helpful to dictate for local government what they should and should not be releasing. If we sit back and wait for the courts and wait for litigation, which undoubtedly is going to come if there isn't guidance from the legislature, it's going to end up being much more expensive for local government and far less predictable.
I'm going to harp on the relying on the courts a little bit. Within the last couple of years, there was a case in which a circuit court judge ordered release of the Child Advocacy Center statement or interview of a child who'd been the subject of very serious abuse. And Jill, you recall that incident, and how did you react as a victim advocate? How did you perceive what that could do in the future?
So this, just to tee this up just a little bit more, the case was about to go to preliminary hearing, and it was a torture case. And it was, the interview of the child had taken place at a child advocacy center, and we have many child advocacy centers around the state, and they record the interview. The idea being that the child victim only has to testify once, only has to answer questions once. You can use the videos in court. And at the time of the preliminary hearing, they wanted to, there was some question about whether the judge had already seen the video, the defense attorney had already seen it, the prosecutor had already seen it, and they just wanted the judge to take notice that the judge had already seen it, and they wanted to set the case over for another day so another witness would be available later in the week. And the judge was about to seal the video into the court file, and a member from the media said, I want a copy of that video. And later on that afternoon, they had a hearing, and again, the media was represented, the defendant was represented, the state was represented, and the victim wasn't. and the video was turned over to the media. The preliminary hearing had never happened. For those of you who don't practice criminal law, there's no discovery until well after the prelim, which is at the arraignment. And it was, I got more emails that day from all around the country saying, we can't believe this happened. This is horrible precedent, and we're very concerned about what's going to happen with Child Advocacy Center tapes going forward. Luckily, we didn't see that happen.
Was it satisfactory that when this was put up in the media, that it would be, the victim's face would be blurred or voice would be disguised?
The judge asked the media to be careful, but you could, she moves in her chair, and so while they're black, they're sort of blacking out her face. When she moves over, you can see her. And the way they do these forensic interviews with children in many places is there's a whiteboard behind them, and the person is taking notes because kids are so visual, and they'll be taking notes or drawing pictures, and some of that also showed up. This went viral. I had the Dane County DA's office shared a report with me, and they just, it was all over the place.
You know, and I think it was Jeff who made the assertion that most media are responsible about these kind of issues and do not reveal the names of victims. Most media isn't the same thing as it was even 10 years ago. Now, media now is, there's a kid from Wisconsin who's a 100 millionaire because he has his own YouTube channel, and he's putting up all sorts of stuff. And there are all sorts of people who are now putting things out in the public forum that wouldn't have been there before. Should we address laws that deal with people who aren't going to be responsible with that information? Should we authorize law enforcement to take out names? Because right now it's not clear we can.
But the custodian can.
Well, that's what I'm referring to, the custodian of the records for law enforcement.
I could maybe take a stab to start with. The law is not written for mainstream news media or the newer forms of news media. It's written for the public. The news media has no greater rights under the open records law than anyone else does. And so I do think the law recognizes that the dissemination may be through the mainstream news media, but it may be entirely otherwise. And certainly information gets out there quicker, it stays longer, it gets disseminated more broadly than it ever has before because of electronic means that are available. But I think, again, for the most part, that's a good thing. I mean, we want transparency in government. We want information about how government officials are conducting their business to be available for the public. There are circumstances where privacy concerns, whether they are codified or not, need to be taken into account through the balancing test. But again, I think we're better off trusting the custodian's judgment. And with respect to victims, for example, there's it's an area where there is discretion and where custodians need to take their job seriously, and where again education, training, should be sufficient rather than trying to completely revamp the law. Because I think if you open it up and you say, okay, for body cams we're going to have to change things, for victim names we're going to have to change things. There's a lot of protections right now in the laws, both not in the open records law itself, but in the juvenile laws and criminal laws for juvenile identities. And I don't have the background to respond to the scenario that the Attorney General and Jill discussed. But for the most part, that is actually off limits with limited exceptions. So again, I'm not suggesting that there aren't ways we can improve the law. I don't think we should gut what's there and try to replace it with laundry lists for every type of record. I just think it's a morass that's going to end up causing more problems than it's worth.
We're down to the wire. Any last words from any of the panelists? You looked interested. Okay. Well, obviously the discussion on this topic will take much more than the hour and a half that we just had. But thank you very much to our experts for coming today and presenting this interesting perspective.
And we just have a couple quick announcements for you. One is Of course, I get to be the bearer of the bad news. Apparently, that's my job description. We are not validating parking if you parked in the concourse.
Let me off the stage before.
I'm sorry. Take all the free half and half you want. I don't know what to say. We'll validate you in other ways all day today. A number of you asked, a number of the media outlets have asked if they could have a few minutes with the Attorney General. So we have a 15-minute break right now. We ask you to be back at 10:45. Right outside this room, we'll make AG Schimel available if any media want to ask questions about anything your heart's desire. So please be back at 10:45.
All right.
Great, thank you. Oh, okay. Got it.
All right, everybody, we're going to get started again. Can everybody take their seats, please? Geez, I'm not used to people doing what I say. It was kind of nice. We were sat down. So just a reminder, if you're tweeting with us, we have a hashtag. It is hashtag AG Schimel Summit. And I'm seeing lots of traffic on Twitter, so we're liking that. Thank you very much for doing that. And now I want to introduce you to our Deputy Attorney General, Andy Cook. I promised you a fun fact about just about everybody. Andy actually used to be in the state of Washington. He was on the Washington Coalition for Open Government. So this is a subject that Andy's familiar with, and I'm going to bring him up to you so he can tell you about the next panel. Andy?
Well, thank you, Annie. Since Annie is doing fun facts, I guess I'll do a fun fact about Annie Schwartz. Annie Schwartz started her career covering the Jeffrey Dahmer murder, and actually is a Pulitzer Award nominee for her book, The Man Who Could Not Kill Enough, The Great Murders of Milwaukee, Jeffrey Dahmer. So you can get the book on Amazon. So I just gave you Amazon. Yes, there you go. Well, thanks for the introduction, Annie. Before we begin, though, I'd like to also thank a number of Department of Justice staff who made this work today, who aren't here. Some are today are here, but some who are back in the office. So I'm going to read through the people we need to thank. John Cormenis, who's running around. He's the one that really made this all work in the back. Thank you, John. I'll now read through the rest. Ave Grossenheider, who is our intern, Peggy Sue Smith, Donna Hahn, Ann Zenner, obviously Annie Schwartz, and Delaney Brewer, who were instrumental in making this happen. And then lastly, I want to introduce Paul Ferguson, who's heading up our Office of Open Government. So I'm not sure if Paul wants to raise his hand right there as well. So, very good. So our panel today is, the title is The Public Records in the Modern Era. So as the Attorney General noted in his outset, the last time the Public Records Law was substantially amended was 1981. To provide perspective on how long ago that was, President Reagan was in his first year of office. I was in the first grade. and IBM introduced its first personal computer that year. So given the considerable advances in technology over the past 34 years, the Public Records Law is probably in need of some update, as we've discussed today, obviously without compromising transparency. So today I want to introduce what I think is an all-star lineup of speakers. Each person's going to be given roughly 10 minutes to speak. And at that point, I'll kick it off with some questions, and then finally we'll get some questions from the crowd as well today. I think it's also important before we begin to note that it's important to note that the statements and opinions made by the speakers are their own and do not represent the opinions of their respective employers. Mr. Tafora asked me to say that. So with that, I'm going to introduce the panelists, starting right here with Mr. Tafora. Raymond P. Tafora was appointed the Vice Chancellor of Legal Affairs in September of 2013. In that role, Mr. Tafora serves as the General Counsel of the University of Wisconsin-Madison and is a member of the Executive Committee. Prior to his appointment, Mr. Tafora was an attorney in private practice at the law firm of Michael Best and Friedrich for over 18 years, where he specialized in matters of governmental, administrative, and regulatory law. Mr. Tafora has previously served as Chief Deputy Attorney General in the Wisconsin Department of Justice and the Chief Legal Counsel to the Governor of Wisconsin. Mr. Tafora earned his Bachelor of Science degree from the University of Wisconsin-Madison in 1983 and his law degree from the UW Law School in 1986.
You have to mention the dates.
Sorry, they're in here.
I remember 1981, by the way.
Rick Essenberg is the founder and current president and general counsel of the Wisconsin Institute for Law and Liberty. Rick founded WIL after a 4-year stint on the faculty at Marquette University Law School, where his scholarship concentrated on law and religion, election law and religion, the regulation and nature of public discourse, and Wisconsin Constitution. He also continues to teach at Marquette as a member of the adjunct faculty. Rick is a frequent columnist for the Milwaukee Journal-Sentinel and is a commentator in both the local and national media. Rick holds a JD from Harvard Law School, where he was the editor of the Harvard Law Review, and a BA in political science from the University of Wisconsin-Milwaukee. Robert Dreps is a member of the Litigation and Media Practice Group at Godfrey & Kahn. He is an experienced litigator whose practice emphasizes media law, including defamation, privacy and access cases, healthcare litigation, political law, and insurance litigation, including defense and coverage issues. Bob graduated first in his class from the University of Wisconsin Law School, where he was a member of the Order of Coif and the Wisconsin Law Review. Following graduation, he served as a law clerk to the Honorable John W. Reynolds, the Chief U.S. District Court Judge for the Eastern District of Wisconsin. And at the end, Roger Allen has served as an assistant attorney for the city of Madison for 20 years. He has litigated hundreds of municipal ordinance violations, including trials and appeals of intoxicated driving cases. He also represented the city in many other areas, including labor, government administration, and general practice matters. He has represented the city in several administrative cases before various agencies, arbitrators, and tribunals. Mr. Allen now represents the city in civil litigation involving public records, open meetings, labor, and legislative matters. He attained his bachelor's degree from the University of Wisconsin, Platteville. He majored in criminal justice and psychology and graduated with honors. He obtained his law degree from the University of Wisconsin, graduating with honors, and awarded the Order of Coif. Mr. Allen is married and resides in Madison with his wife, their family, and 3 dogs. So with that, I'm going to turn it over to Mr. Tafora.
Thank you.
You ask a bunch of lawyers to handle technology.
I know. Well, how's that for some suspense before you start a speech? Thank you, Deputy Attorney General Cook, and it's nice to be with all of you today. One of the things I thought I'd do today, given my I'm embarrassed to say 30 years nearly 30 years of practice of law in various capacities, as Andy has indicated, is talk to you about my observations about the public records law in perhaps some key areas where I think it's worth, as the Attorney General explores potential amendments, where it's important to I think be nuanced and be careful about either amendments to the law or clarifications to the law, either through the legislative process, through litigation, or through the Attorney General's opinion function, which is also an important element here. First of all, some basics. As we all know, and I think we should all realize, when it comes to the public records law, assuming that you have a record, the presumption is that there should be public access to the record. Now, the presumption is rebuttable, and the record's access is not absolute. But for those of us like myself in the agencies, I think we do ourselves a great service by first remembering that presumption, that if you have a document that otherwise qualifies as a record, that the general rule is that public access should be available for that record, okay? More about requests in a moment. Number two, importantly, however, there are exclusions to the definition of a record that we all know. I think among the more important exclusions to the definition of a record is what is called, is drafts and notes and et cetera. Those of us in the agencies make fairly extensive use of that exclusion because it promotes in an appropriate way deliberation and thoughtfulness and those sorts of things, all of which is highly desirable in public and private agencies. And when important correspondence or documents have to be identified, ultimately for the agency head, in my instance, the Chancellor of UW-Madison, or a dean or whoever, it's important to be able to share thoughts about preliminary documents, et cetera, without having those documents prematurely disclosed. Now, having said that, we all also know that you simply can't mark something a draft and keep it in perpetuity or use it to memorialize agency conduct. But importantly, from my perspective, would be preservation of a fairly nimble, flexible drafts exclusion, I think, is something that's very important. Third, the records that are accessible have to be have to have some relation to the function of the agency. Now, in 95% of the cases, that's always going to be the case. I know the showcase sort of blurred the lines a little bit in terms of whether or not personal emails are accessible. It depends upon whether they talk about public functions and public responsibilities and so forth, but I think that's also very important. Fourth, we all know that among the exclusions, there are both statutory exclusions for access to records and judicial decisions that provide exclusions. There's also the all-important balancing test. And this provides, I think, additional amounts of flexibility for public agencies because the legislature and the courts cannot craft every conceivable good public policy reason for not releasing a record. And it's important sometimes to have access to the courts and be able to develop exclusions based upon good public policy reasons. And let me give you an example. Unsurprisingly, the University of Wisconsin does a lot of research. The research is funded both by the federal government and by industry. Industry also sponsors research. And there are times when, absent a specific statutory exemption or a case that's right on point, you'll want to be hesitant, and the state, I think, would want to be hesitant about the premature release of research which may be a predicate to a patentable device or research that promotes and encourages highly talented faculty to come here, because if there's easy access to that sort of information, we're going to have problems with attracting faculty, because faculty do peer review, they come up with papers, they do research, as I've indicated, and you want to preserve flexibility in, I think, the balancing test, in addition to the other exclusions that may exist, some of which are perfect, some of which are less perfect. Fifth, in terms of timelines for answering public records requests, I know the law indicates that the test is, quote, as soon as is practicable and without delay, close quote. And I can't think of a public agency that actually technically meets that requirement. I mean, it implies that you have to sort of drop everything and immediately get to the business of satisfying a records request. I think most agencies, in my experience, do a conscientious job of trying to meet those. But at a place like the University of Wisconsin, which is a vast decentralized empire. For those of you who are interested in history, it sort of approximates the Austro-Hungarian Empire minus Franz Joseph. And because you have central administration, you've got faculty, you've got academic staff, each have their own powers and privileges. And by the time we get a records request, we in central administration don't really know if we have the information. We send it out. It may go through a variety of different units and colleges of the university, and any one of a number of the 17,000 employees we have there. It takes some time to get to those. And we have, notwithstanding that, we have very conscientious people. Lisa Hall, our records custodian, is a centralized administrative official. It handles all the requests. One of my colleagues, Claire Dolly-Molly, spends almost full time just counseling those as to whether the records law applies or not. So in terms of the statutory language is what it is. I know DOJ advises 10 business days. I would encourage those of you in the requesting community, as I'll call it, to occasionally not just write letters requesting records, but sometimes lift the phone and follow up with the records custodians. My experience is most of them, again, are conscientious. It helps to have a conversation, and it helps to have a pleasant conversation, I might add. The old adage, honey is more attractive or attracts more flies. I'm not sure why you want to attract flies, but honey is better than vinegar, however the adage goes, is a good thing. I mean, and we all know the law. Please don't put in there that the law says the standard is as soon as is practicable and without delay, and we'll see you in court if you don't get to it, because we understand all of that. But I do think that some flexibility, particularly in the Attorney General's advising of agencies as to what's the appropriate timeline to respond, is also very appropriate. Let me also just say a few words, if I could, about the Attorney General's role from my experience. This is the Attorney General's Summit. As a former Deputy Attorney General, I feel at liberty to talk a little bit about the Attorney General's office in a way that the current Deputy Attorney General cannot. So let me within appropriate guidelines, say a few things about that. Number one, the Attorney General has a difficult role because he both has the responsibility by statute to potentially advise requesters as to what the public records law means and says, but at the same time, he's the attorney for the state. So it's a real management challenge. And for the new attorney who's heading the open government section, my advice would be make sure you check in with those who also are advising the agencies as to the scope of the public records law, because people like me and Claire and others are going to be talking to people like Andy Bensky and others about the scope of the law, and it'd be preferable not to have the open government attorney at the same time, I suppose, advising those requesters on a similar subject, lest there be conflict-related matters. Two, I think there is, and I hope this isn't because I'm a former employee of the office, there's never been a better or more needful time for the Attorney General as a law officer to try to give conscientious law advice. Regrettably, we're living in an era of increased political polarization, and we need an officer who can advise agencies and the public as to what the law actually provides. And the Attorney General, be it in the counseling function or in the opinion function, in addition to recommending changes to the legislature about the public records law, serves an extremely useful function. Thank you.
You know, it's funny, Andy said, well, the open records law was passed in 1981 and makes him feel old because he was in first grade back then, and it makes me feel really old because when I think of 1981, the first thing that comes to my mind is that I had hair back then. I wanted to I'm here to represent the requester community, being the head of a, conservative / libertarian pseudo-anarchist group in Milwaukee that exists to make the life of government officials miserable. What might I think should be done with the open records law? And, sort of come to this in the context of what happened earlier this month. As I was, settling down on my deck with a glass of wine, and my phone started to light up because there was this thing called Motion 999, which was seen by the requester community as sort of an inverted mark of the beast. The open records law was about to be gutted, and we all responded. It was like, as a scene in Ghostbusters where, there's Gozer the Gozerian is going to come, and dogs and cats live together. Conservatives and liberals sort of rose up as one and expressed their outrage. So I think that there are two things that, if we look at updating the open records law, there are two things that probably shouldn't be done, and three things that require some consideration, although probably wouldn't be a good idea to go quite as far as I'm about to suggest. First of all, this idea of a deliberative privilege is probably not a good one. I understand the context of deliberative privilege in civil litigation, where there's a concern that if people know that their writings are going to become public, they're going to pull their punches. And they're going to pull their punches because they're concerned about civil liability. Now, that could happen in this context, but that's not really what we're concerned about here. What we're concerned about here, and I think it's a real concern, is that people may pull their punches because they're going to be worried about political embarrassment. And I understand that. I would not like to have meetings with my colleagues in which, Dan Bice was off in the corner with an iPad. I would think that that would have a chilling effect on the conversation that we have. And I understand that, people need a little space to operate. On the other hand, the concern to permit exemptions from the open records law to essentially address concerns about political embarrassment seem to go contrary to the purpose of having such a law in the first place. It seems to me that when you're in a position to work the mechanisms of government, to coerce people to do things, to prevent people from doing things, to take their money and to spend it, it seems to me that transparency is the price you pay. Now, it may be possible that there's some type of exploding privilege that might work to protect, some type of, narrowly for some people to protect some type of period when public policy proposals are being prepared. But if it's going to be there at all, it seems to me that it needs to be quite narrow. The second thing that I think ought not to be done is to change the open records law to provide for the substantial protection of the identity of people who communicate with government. Now, we brought a case on behalf of our friends at the McIver Institute against Senator Erpenbach. Nothing special about Senator Erpenbach. He's just the guy that, happened to draw the short straw. And we sought, initially, the identity of persons who had communicated with Senator Erpenbach using government email accounts. Now, if you think about it, that was quite a narrow request. We were only concerned with people who had used a public resource to communicate with the senator about a political issue. Although I fully acknowledge that when we were ultimately successful in the case, the Court of Appeals rationale might go somewhat further than that. And I'm sympathetic to the notion that it is a burden to say to people that, if you communicate with your legislature, your name may become public. That's a burden on a protected activity, just as it is a burden on a protective activity to require that people who contribute to a candidate will have their names publicly disclosed. It seems to me that that both the public interest in disclosure and the concern about disclosure is roughly parallel. And the problem is that even though we recognize that it's a burden and we recognize that there's a potential deterrent effect, we seem to think that it is important to know why a public official is taking a position, as well as to know what that position is and what its merits are. And we seem to believe that it's relevant to know who's urging him to take it. And it doesn't seem to me that, at least a priori, that there's any way for the law to distinguish between a communication from Joe Sixpack, who we may not care much about, and a communication from George Soros or Charles Koch, which might be of somewhat more interest to us. So it seems to me that there's really no way around continuing to deal with that under the balancing test, and that the balancing test, it seems to me, as always, has to be weighted well in favor of disclosure, that there ought to be some real requirement on the part of someone who would withhold the identity of people who are attempting to influence a public official to show that there will really be some harm associated with the disclosure. And if we look at the cases in which people have attempted to assert that type of interest in the context, say, of campaign finance disclosures, the bar is set pretty high. Most of the time, those who seek exemptions lose those court cases, and I suspect that it should be the same under the open records law as well. But I always say this when I'm talking about disclosure, either in this context or in the context of campaign finance, that if you want disclosure, if you believe that's very important, I always say to activists that you ought to try as hard as you can to refrain from retaliating against people who have donated to a candidate or taken a political position that you don't like, because that's when we really start to get nervous about the effects of disclosure. 3 things that should be done. First of all, I think the legislature should probably address the question of location fees. Location fees can be the easiest way to defeat an open records request. Oftentimes, the estimate of a large fee will cause the requester to abandon the request or to be unable to have it fulfilled in a time frame that is relevant to the purpose for which the records are being requested. Now, my colleague Tom Kamenik, who is really the expert on open records law, sort of suggested, and perhaps he had his tongue partly in his cheek, that maybe an idea is eliminate or location fees altogether, or sort of adopt the policy under the Freedom of Information Act when one can, under certain circumstances, request a waiver of those fees if one is not seeking the documents for a commercial purpose and it is in the public interest that they be disclosed. And that seems to me that that's probably a good idea. Other ideas which are perhaps less radical would be to permit subsequent litigation over a prepaid location fee to determine whether it was reasonable or not, with certain incentives provided to the requesters to litigate that issue, perhaps attorney's fees and some type of liquidated damage provisions. Or it may be worthwhile to set up a mechanism for administrative review of a cost estimate. I think that the question of timing should be addressed. I was surprised to learn, to hear again, although I've heard it before, that the DOJ recommends 10 business days. We don't often get a response to open records requests within 10 business days. Now, some agencies do a very good job of responding, but I'll have to tell you, and I could name them, but I won't, there are some agencies and local units of government in this state who we've come to learn that making an open records request to them is a bit like, passing the event horizon into a black hole. The request becomes sort of inaccessible to outside observers. It seems to me that creating a presumptive deadline with the burden on the agency to justify a longer response time might be in order. Finally, and this may not be a major problem, but sometimes we have issues with record retention. Now, there's no general record retention policy. There's no record creation policy. Quite frankly, I can't conceive of what it ought to be, and am not inclined to go down that road. But it is necessary to retain records once a request has been made, and I have no doubt that most agencies do that. I generally tend to find that about 98% of the people that you deal with are honest and diligent. But there is no enforcement mechanism if that doesn't happen, and perhaps one needs to be created if the law is to be revisited. So that's a perspective from, as Ray puts it, the requester community.
Well, good morning. I'd like to begin by thanking Attorney General Schimel for organizing the forum. I was enthused when he said he was really going to approach updating the law that's been suggested in the past, and it's never actually come to fruition. Unfortunately, the atmosphere was poisoned by the action of the Legislative Finance Committee in the budget process. Motion 999 was mentioned. That seriously poisoned the atmosphere because it demonstrated that legislative leadership, at least currently, does not support the policies underlying the public records law.
reminded me of the opening lines from the Schimel decision from 2010, just 5 years ago. If Wisconsin were not known as the dairy state, it could be known, and rightfully so, as the sunshine state. All branches of Wisconsin government have, over many years, kept a strong commitment to transparent government. At the time, I remember thinking, it's a bit hyperbolic, but most people would generally agree it's true. Today, I don't think any objective observer would agree that at least the legislative and executive branches agree with that principle. The open meetings law has been flawed from the beginning by an exception for partisan caucus meetings. That's where the real business gets done. The legislature, from the outset, created a different rule for itself than it imposes on local governments. We've all become accustomed to that, but it ought to be revisited. Today, no part of the open meetings law can be enforced against the legislature. That was the outcome of the Ozone decision in 2011. In the 2011 legislature and the 2013 legislature, resolutions were introduced to correct that problem by amending the state constitution. It's a separation of powers issue, and so the only way to fix it is to amend the Constitution. Those resolutions went nowhere in the legislature for lack of support. But you can look today at the state's official policy in that statute, 19.81 sub 3, and it says it is declared to be the intent of the legislature to comply to the fullest extent with this subchapter. It's not true. They don't have to comply. When push comes to shove, they can close their meetings without fear that there will be any consequence other than in public opinion. Well, that's not enough. Public opinion didn't prevent them from trying to introduce this bill without any prior notice that would gut the public records law. Public opinion forced them to back down, but they haven't given up. Those proposals would have redefined public records to exclude deliberative materials, undefined. It's the same argument the governor and the Department of Administration is currently pressing under the balancing test in court. That's a misuse of the balancing test. Balancing test is supposed to be case by case. If your application of the balancing test results in a rule that will apply in every future case, that should be done legislatively. And of course, if you're going to do it legislatively, it should be done through public hearings and debate and an open and transparent vote. I would support the use of the legislative council process to address updates to the law in the area of electronic records and some other improvements I could suggest. I have been doing this for 30 years. I'm not embarrassed to say. I enjoy doing it. But there are two quick fixes that could eliminate most of the litigation under the records law. One, there should not be balancing test of disciplinary records of public employees. You want to work for the government, you want to engage in misconduct in your job, the public is going to find out. That's your employer. Your employer is entitled to know how you perform your job. The balancing test holds out the hope to some employees, maybe your case will be different. Maybe if you go to court, it won't come out. It's never happened. Nobody has ever won one of those Woznicki challenge cases that I know of that's been litigated. So why do we do it? Why do we go through this fol-de-rol? Why do we suggest to public employees that maybe on a case-by-case basis you can justify keeping your misconduct sanction secret? It shouldn't be. Law enforcement records. That's rarely litigated, but it causes disputes all the time. Maybe it is impossible to have a laundry list that anticipates every circumstance, but some states manage the process quite well. James Friedman mentioned the Minnesota law. I've long recommended that approach. It defines what is required to be in an incident report, and it says that incident report is always public. It then goes on to define investigative materials and holds those confidential until one of three things happens. The case is prosecuted successfully or not, the time for prosecution runs, or the government decides to abandon its investigation. At those 3 points, any one of which will occur eventually, the records are again public, unless they identify confidential informants or some other, implicate another ongoing investigation. Every law enforcement officer in that state knows when they put pen to paper or keystroke a report on their computer that it will likely eventually become public. In Wisconsin, people don't have that assurance. Law enforcement can reasonably expect that most of their records will remain confidential. Our job as attorneys is to advise our clients on how the law applies. I get a call on the hotline we run for reporters, and they ask, can I get this police report? I have to honestly say, I don't know. You have to ask for it. You have to see what they say back and then consider whether it's worth going to court to fight about. Litigation over law enforcement records is rare because it's case-by-case adjudication, and it takes time. You can't establish a precedent under our common law balancing test that'll apply in the next case, even if it looks identical. All the custodian has to do is to say, for some reason, the balance is different this time, and you're off to the races again. The news business can't afford to do that constantly. You don't establish a principle that's going to count the next time, then what do you accomplish? By the time the courts make up their mind on that dispute, the information almost certainly has come out through other means in the court process. So we're left with this gray area that causes disputes, causes expense to custodians, unnecessary, and black and white rules would be preferable. So I favor a Ledge Council study committee for other updates to the law, and I do that with some trepidation. In the requester community, we've long been wary of opening the door to tinkering with our transparency laws, because the unfortunate result is that sometimes they're made worse. I participated in the Ledge Council study committee that developed narrowed the Woznicki rule to what we currently have in section 19.356. And the leaders of that study committee did a remarkable job of beating back most of the attempts to add additional stuff to their mission. Their mission was to address the Woznicki problem that burgeoned from a court opinion that didn't have the kind of careful consideration before it was dropped into the law. Senator Erpenbach and then Representative Mark Gundrum did a fantastic job of beating back most of the attempts to bring in extraneous stuff, but it happens every time. At the same time, it's the only process I'm aware of in our state government that allows for careful and deliberate consideration of best practices in other states. We don't have to reinvent the wheel. There are 50 different states that have public records laws, some frankly better than ours, many not as good as ours. But they all have different experiences, and we can learn from them. And we can take the time to do this correctly and address electronic issues and the rest of that. But I also wouldn't rush that process. I would not present the results of that committee to this legislature, at least not until they have faced the voters and explained their intentions with things like deliberative process privileges and redefining records and excluding basically all information about how they do their jobs that they don't want the public to see. I would rather see them face the voters first in 2016 and explain to them, if they still want these privileges and these exceptions, why they think that's good public policy, and whether or not they support the recommendations of a legislative study committee on the other issues. As currently structured, I would not trust this legislature to do the right thing. If they're presented with proposals from this process or a Ledge Council process before they have to face the voter and discuss these issues, I'm concerned their priorities will be as they were on the 4th of July weekend. I'm sorry to have to rain a bit on this parade, but that's the way I see it. Thank you.
Well, good morning. I'm sort of reminded of high school baseball because I'm batting cleanup after an extraordinary lineup. It's pressure's on. I had some prepared remarks, but before I'm going to abandon them. Let me tell you why I'm going to abandon them. I'm batting cleanup, got to have that home run, and I'm neither Lincoln nor Jefferson, so if I have any hope, I'm just going to have to speak to you from the heart today. I want to thank the AG and his staff for this seminar, but I also want to thank the members of the Madison Media, Bob Dreps, I see Bill Leaders is here, Tony Galley's here, I think I saw Dean Mosman, because we have a collaborative process in this area. They know that if we have a disagreement over what's been withheld by one of our records custodians, they call me, and we'll have an honest discussion about why we've done what we've done and whether we can reconsider based upon their arguments. To the maximum extent possible, we release records to requesters. Now, I'm of the opinion, guided by 16 years of practice in this field, but more so by a lifetime where I've been privileged to serve the public in the military, in law enforcement, and as an attorney. That has taught me that an informed electorate is truly the basis of a working democracy. Democracy withers and dies in apathy and ignorance. It thrives, though, when we have the information necessary to choose to do the harder right than the easier wrong. This law works. It works extraordinarily well. But are there changes that can be made? Yes, I believe there are. And now, here's where all my thunder gets stolen by batting cleanup. Jill Krofsky did an excellent job about talking about victims' rights. State law provides that I, as a records custodian, cannot release the home address, home email address, home phone number, or social security of a public employee unless they have previously consented to such a release. But when it comes to crime victims, there is no such protection. I struggle when we get requests for large databases whether or not we're disclosing to some stalker, to somebody with a restraining order, where their victim currently resides. And in fact, we had personal experience in last year with that, with somebody using the public records law to go to other custodians to find the home addresses of our police officers and show up on their back porches. We had more than one angry spouse call us about that incident, or those incidents. We also need to do a better job of protecting that sensitive, personally identifiable information that we have in our public records that can be exploited by identity thieves and social engineering. We don't have any guidance on that in the current law. We have amassed large databases that can be used for the purposes of mailing lists. In fact, there's a statute that says government cannot sell mailing lists, Section 19.71 of the statutes. However, it says it's not selling those lists if we produce them under the public records law. The public records law is to inform the public about the operations of its government. But I don't think the average citizen has any clue that when they go golfing at Yahara Hills, or when they get a pet license, or when they pay their property taxes, that they have now been entered on a database that can be released to any solicitor in the world. It's interesting that under state law, if you get your driver's license, when you renew your driver's license, ask the clerk if you can have a copy of Form MV 3592. That will allow you to opt out of having your name and personal information released to any person who makes a request for more than 10 public records. In other words, those people are compiling mailing lists. We have no such authority at the local level. Another area I think the law can address is what to do about the serial, what I call the serial requester. That's a person who takes a large, unprocessable request for any and all records you have on a various topic and breaks it down into multiple requests. I actually got one of those with, it was about 40 pages, all separate requests, all in the same envelope. The problem for custodians, usually these are spaced over a couple of days, but this person cut right to the chase. The problem is if we deny any one of those individually or we try and process them individually, we're overwhelmed. And we quickly cannot answer the other requests of other persons that are coming forward. The near universal practice of custodians in this state is to aggregate those multiple requests from a single requester into a single request and process it as though they had submitted it as a single request. Then if we can process it, we will. If it's unduly burdensome and overly broad, we'll deny it. I do want to put a big caveat on when I say deny. As members of the Madison media know, it's not our practice to just outright deny on those bases. We will call a requester, engage in a dialogue, try and clarify their requests, and get them what they want. It's their records, after all. But I would like to see the state law incorporate that type of practice for those people who submit serial requests. Retention schedule reform. Currently, a municipality has to keep records for 7 years unless it goes to the State Public Records Board and requests a different retention period for a class of records. The State Public Records Board appropriately looks at not the format of the record, but the content of the record. The problem with that is it doesn't match the way we look at records these days, particularly with electronic records. So let me give you a real world example. Email. If you have to look at the content of the email, you're really relying upon the creator of the email or the custodian of the email to determine by its content how long it will be held and retained. We've seen at the national level what can happen with that type of authority. Plus, another problem for us as records custodians is if we're retaining 7 years of email, which we do in Madison, and we have it in a database where we can search it by keywords, the problem is if we're keeping 7 years of records, we're not looking for a needle in a hay bale, we're looking for a needle in a barn of hay. And it gets much more difficult to respond to those requests. So I would like to see us adopt a best practices rule that limits the retention of those type of electronic records. Simple one, no payment, no records. We process records requests in Madison largely on a good faith basis that if you're somewhere around $5, we're going to get you the records request and bill you. We're repeatedly burned on that. And the problem is the statute allows us to withhold records from a prisoner or committed person who has not paid for their prior records requests. It should be the same for all people. We believe there should be a digital technology update to the law. We did this in Madison. We had a collaborative process where we engaged Bob Dreps, other attorneys representing the media, and members of the media, members of the insurance industry, because they're a large consumer of our public records. They want police reports about damage to property. They want accident reports about damages to vehicles. So we sat down with them and said, this law doesn't give us enough guidance on what to do with electronic records and other records. And we worked out a process that I think has worked quite well. Don't you think so, Bob? I do. For about 10 years now. It probably needs updating as fast as technology is advancing. I was on vacation with our family about 2 weeks ago. I was surprised to learn that the cabin I booked in the Blue Ridge Mountains that didn't have Wi-Fi, that didn't slow my kids and their tablets down one bit. They're going to be paying that bill for the data. I would like to see a definition of the news media. It's going to be tricky and hard to come up with, but the problem is today, what is the news media? If you'd asked anyone in this room 15 years ago, who's the news media? I think they could rattle off to you their local stations, their local newspapers, but we didn't have bloggers. We didn't have independent media news sources. With regards to the Juvenile Justice Code and the Children's Code, the news media has an opportunity to see records that are confidential and to report on those records so long as they are not identifying the child. But who is the news media? That's not defined in those statutes. This person who went around and found our police officers' addresses said he was doing it for his blog. Interestingly enough, we couldn't find the blog. But I would also like to see if we could come up with an acceptable definition of the news media, that the news media be given an opportunity to have a sneak peek at some records, particularly public employee discipline records. I respectfully disagree with Bob that public employment is a forfeiture of all privacy rights. I don't believe it is. I don't believe the courts have adopted that position. I do agree that if I mess up, Bob, I'll send you the records. But if my secretary does, and it's a minor issue, I don't think the public has access to maybe her name or his name, but maybe the facts of the incident would be appropriate to release. Otherwise, in this day and age, I believe that there are intrinsic rewards in public service, but I will tell you, not all people do. They take it because it's a good employment with good benefits and good working hours, if you're not an attorney. So we need to be able to recruit top employees. I believe that if you put the specter out there that all of your records are open to the public, we're not going to get the best candidate in some circumstances. And now, what I think is a piece de resistance, my son told me, don't try French, Dad, is that we provide a streamlined administrative appeals process. You know, this law works really well in Madison, and I heard a lot of concern about, well, where are law enforcement going to get their advice if it's not in the statutes? And I thought, well, me? And that works really well in Madison, but does it work so well for the village of Rio, where you're billed for every contact with a city attorney, or where the city attorney may not be available to you as readily as in-house counsel? It would be nice to be able to have a third-party arbiter. The Attorney General's office does issue opinions when requested, but to have a formal administrative appeals process that's no cost or low cost, because I'll tell you what, most members of the public, myself included, having made public records requests, give up if they get a denial letter. It's too expensive. It's too hard to find an attorney that specializes in this area. Bob drops an exception. But the public should have the benefit of a third party whom they can trust is not being involved in that record to make a decision that will be consistent throughout the state. And that's one of the problems of the court process. Until we get to the Court of Appeals or Supreme Court, there's a likelihood that different judges in different counties will engage in the balancing test and place different weights on different factors, and will have inconsistent results. In closing, I want to say that these are what I consider to be tinkering at the edges, maybe not the administrative appeals process. But the law has worked exceptionally well. And I think it works well because the people involved both in the media, in the public sector, work hard at arriving at conclusions that serve the public interests. At the bottom line here, the only reason to withhold records from the public is that it's going to be damaging to the public interest. That's the, the factors we have to consider are, does the law prohibit the release? Does case law prohibit the release? Or does the public records balancing test prohibit the release of the material? Not does it allow us to withhold it, does it prohibit the release? And that means, at the bottom line, all we're doing is looking at the public's records and saying, can we give them these records, or will we harm them by giving them their records? So, thank you very much.
Well, thank you very much to our panelists. Please join me once again in thanking them for their talk. So I think we're going to change it up a little bit on this panel. I'm going to start by asking some questions, but I'm going to then turn it over to you all to ask some questions. But first, I guess I want to start out by noting that I'm a little embarrassed by the fact that that was the only interesting aspect that Annie could come up with, that I was a part of the Washington Open Government Coalition at one point. But the reason I say that is I want to thank you all for being here. It's amazing. We have almost 200 people that showed up for this event. When we were putting this together, I thought we'd have 50 people, but this turnout's fantastic. So thank you, everybody, for coming to today. So I guess maybe I'll kick it off and start off the first question, and anybody can jump in at this point. But as I noted at the outset, obviously things have changed dramatically when it comes to technology. I think one could argue that the law as it's currently written is vague enough that it could provide guidance on what records should be provided that are electronic. But Roger noted that the city of Madison has a policy in place. So I guess I'll just kick it off. Should the current law be amended to specifically and expressly address email messages, text messages, social media, et cetera? And then if so, what would that look like? So I can throw it to the panelists.
I'll take a shot at it. Currently, we're spending a lot of money making daily copies of our social media pages, which we do so that we have the record so we can produce it later for public records requests. And quite frankly, that's the only reason we're making a copy. That's one area where I think it'd be nice if government only had to record changes it made to its social media pages, but not the daily activity on it. You can go there and look at it yourself from day to day. Email, though, is a particular problem for us. We've managed, thanks to the changes in the stock exchange and the requirement to record emails for those purposes, software became available where we could readily capture our emails. But the problem we're finding now is that the database is so huge, it takes us literally days to go through what a requester has asked for. I understand we may be able to charge a location fee for it. Madison has not been so far. But it'd be beneficial to all involved if we could cut that pool to 3 years or less. And given the guidance that the State Public Records Board has, that it's content, not format, which I think is a correct legal conclusion, we can't reach that point.
I mean, I think the email thing cuts two ways. And, you know, we had this problem in civil litigation where, you know, the rise of email has, greatly increased the number of things that get communicated in writing. That it used to be that you'd walk down the hallway or you'd pick up the phone, and now it's actually easier and more efficient to email. So a lot of stuff gets written down now that didn't get written down before. You have more records. There's also this tendency on the part of people to think that email seems to them to be a more form of intimate communication, and so they say things that they would never say if they were writing a formal memo in the past, and that tends to cause problems and concerns on people's part, and leads them to do things like deleting all their emails at the end of the day, which I understand is a practice of some people. And but yet at the same time, it does allow recovery of information a lot more quickly, particularly if requesters frame their request, at least as we often do, in terms of, as search terms, right? You give us emails that have the following terms in them. And it seems to me under those circumstances that providing relief to government agencies is not as warranted as it might otherwise seem to be, and in fact, they ought to be incentivized to organize their systems in a way which allow those that material to be recovered, and we ought to be looking for ways in which that can be done rather than ways in which withholding this information from the public.
One other question I have, and then I guess I'll turn it over to the crowd. Should Wisconsin's law address the medium in which the electronic record must be disclosed? I guess the question there being if there are a number of emails that are caught up in the request, should the agency give that in PDF format or as printouts? The law is largely silent on that. Any thoughts on whether there should be any explicit language to address that?
Well, I think the existing law and requirement is that the government produce the information requested in the form in which it is kept. And if you're talking about email, by definition, it's an electronic record, and it's more useful to the requester in that form. If they want to print out, I'm sure they can request that and pay for it, but it's less expensive and more efficient to transmit it electronically, and that is the requirement. Changing it to the requested format, if the government isn't currently keeping it in that format, that's an additional expense the requester can do on their own once they get the record in the form the government has it. So I don't think that's a current problem at all.
I'm glad to hear that, Bob, because that's not the position of all requesters. There is an old Attorney General opinion out there that talks about if you have an electronic record and with a few keystrokes you can convert it to a different record or produce a record, then you possess a record. And there's a court case, I'm drawing a blank on the name, involving assessor's records where there was some discussion about, well, if the custodian could easily convert it. The problem for us, and this gets back to the mailing list of people who are not accessing public records to learn about the operations of government, but rather to package and resell government records as something different and profitable. The problem is it takes some time to convert these records, probably enough for us to really bill for it, but it becomes death of a thousand cuts when we have multiple requests to have these records converted from Excel to some other exotic format that we may have. We would, if there is change, it would be a welcome change to underscore that which is in the law already, that we should not have to change the format that we possess it in. If we're using it in that format, that's the format we should have to produce it in electronic records.
All right. Anyone else? So at this point, we're going to turn it over, and we'll ask that you speak into a microphone. We'll have our intern Ave come up and grab one of these microphones, and if anybody has a question, she can run to you and give you the microphone. So do we have any brave souls to kick it off? I know we have reporters in the audience, and they're not typically shy, so anybody from the media?
And this is for Ray Tafora. Ray, you had been talking about the deliberative process, and there have been published reports in the Milwaukee Journal Sentinel to indicate that Governor Walker's administration has relied in some part on a deliberative process exception to withhold records that had been requested. And my question to you is, as the law is currently structured, does the University of Wisconsin believe that there is a tentacle that would allow you to also withhold records of the deliberative process?
I have learned in my public career that one ought always proceed carefully when answering a question posed by Tony Galley. So consistent with that spirit, Tony, and I note that the question comes in the form of, should you rely on this tentacle? You know, when someone uses the phrase tentacle, that he has a view as to this particular exclusion. Tony, I would say this. Recall that my reliance on sort of a preserving a process of deliberation was in the context of the drafts exclusion. My own view is that there isn't currently a deliberative process privilege that's available under the records law. And we would not in the typical course, obviously, that therefore advise University of Wisconsin officials that there's a deliberative process privilege. The only other thing I would add to that, and this comes as wearing my hat as a former counsel to the governor, then Thompson, There is an AG opinion, although it might have been subsequently changed by the Open Records Law amendments of 1982, written by then Attorney General Warren, that says that the governor, like the President of the United States, has an executive privilege, or at least a limited executive privilege. I don't think it's been invoked. We never invoked it when I was on the Thompson staff, and again, I think it very well, others may have different views, but it very well could have been partially abrogated by the amendments of 1982 to the records law.
Anyone else? Right in the back row there.
Just a follow-up to that would be, do you believe that the current litigation over the deliberative process could lead to that becoming an exemption under the public records law?
Maybe you want to give context, whoever answered the question, as to the current case that's going on right now.
Could it happen? Yeah, these days I would not put anything past any branch of our government. Should it happen? No. It's the kind of, like any exception, if you're going to consider it, it needs to be thoroughly investigated, best practices considered, and debated publicly before it's voted on by the legislature. It's not something that should come through a common law balancing kind of approach, which by its own definition is supposed to be case by case and not lead to comprehensive principles that apply in every future case.
In the back.
Thank you. I'm a reporter, so I have a reporter type question. We're running into a lot of small government bodies, particularly school boards, who have decided to go to paperless meetings, where each school board member has a laptop computer there on the desk in front of them. The administrator has a laptop computer. Nobody in the audience, including the public or the media, has access to the information that's being viewed by those people. And if you ask for a copy of it, they say, well, you have to submit an open records, public records request, and we'll get back to you in a few days. How can we deal with situations like that? And I'm really asking this probably of Bob and Rick.
I've not heard of that. Bob, have you?
I have.
And then why don't you address it? My initial reaction, of course, you asked a reporter's question, and I would give you a lawyer's answer, and that is that we ought to get a bunch of guys together and sue them. It seems to me that strikes me as any good lawyer should be able to argue that that's an open meetings violation. But we have actually a good lawyer here, and he's probably got something to say about it.
Well, I like suing people as much as the next guy, but I think some people overlook the other self-help remedies we have in a representative democracy. These people run for office every 2 years. And if you have an editorial page, you can ask them for a commitment to end that practice before the next election, or you can simply endorse somebody else who says they will abandon that practice, because the law, computers are wonderful and make access to information easier. The public should not be charged for those laptops held by those public officials and stuffed with their information. They shouldn't have to pay for all of that, only to be told that it's less accessible than it was when everything was kept on paper and people spoke to each other in public instead of through their devices. It's just a step backwards. And we're paying for this government by electronic media. We ought to be entitled to see it. It's just a question of records access. The fact that it's on a computer instead of in a folder full of paper in front of the elected official does not change one bit the public's right of access to it. And in fact, it ought to be more accessible than the paper because it can be transmitted so much more easily and with less expense. But there has to be, even under current law, a mechanism to make those documents, those records, electronically stored information, subject to public inspection and copying if they wish.
All right. One more in the front here.
Thank you. I'd like to speak to what this gentleman just talked about. We have this problem in our community. Even though we don't have computers in front of our board members, they don't bring with them any extra documents for the people attending the meetings to see. And when we ask for copies of the minutes of the meetings, for example, that were approved at that particular board meeting, we were told you have to submit a public records request for that, even though each one of those board members has all that information in front of them. So what we did was mount public records requests. I call this public records request retribution. And we made it uncomfortable enough for them that they finally did start making, five copies for you if you were to come. Now, our town has a website, and occasionally that information gets posted in a timely manner, but there are no policies that will really ensure that. So it's up to us as the constituency to stay on top of that information as much as we can. But when we talk about the rights of the individual to have that information, I think the other side of that conversation is how some, very few I believe, but how some public officials use that records law to punish you if you ask for it.
Did you have one, or? Okay, one more, and then and then we're done. So last one right here.
So I'm going to continue on the topic of education, I guess. I'm just wondering, to what extent are certain laws applicable to a record that, is either perceived or considered public information or contain public information that are from law enforcement affiliated with the UW system? And what I mean by laws are like privacy laws under the Constitution, balancing tests, and the Federal Education Rights Privacy Act.
Well, the records that are held by, say, UW-Madison Police Department are generally accessible, okay? There are going to be laws like FERPA, which is the law you're talking about, the Federal Education Response, I can never remember what FERPA is now. Thank you. That will apply, although in general, those types of records are accessible. There are exceptions in FERPA for law enforcement related records. But those types of, we get records requests consistently from members of the media and others for records that are held at UWPD, and we service them in the same way that we would service any others. FERPA is generally a bar to any, quote, education record, close quote, as defined under federal law. Again, one of the exemptions, well, the student themselves can get access to their own records, but there are exemptions for a variety of certain student disciplinary records and law enforcement records as well.
Very good. So with that, hitting 12 o'clock, we're scheduled to go to 12:15, but for those who are not having lunch here, we're going to depart now, allow for time to get back here at 1:15. For those of you who are eating here, on your name tag, it's red. That signifies that you have paid. You can go out the doors, and then to the left and down the hall, that's where the food will be served. We'll come back here at 1:15. And again, thank you to our panelists today. Thank you.
everybody ready to take your seats and have more fun? Did everybody get to the dessert room? You guys didn't find the dessert room with all the pastries? Oh, kidding. Huh. I know. Our next panel is the cost of open government. So we're going to have, we need to get our 3 panelists up here along with our moderator. So we need Jamie Aulick, Stacy Hoffman, and Bill Leaders. And moderating the panel is going to be Assistant Deputy Attorney General Delaney Brewer. The fun fact about Delaney, she gets mad when I say this because she says, I want people to think I am kind and gentle. And in Delaney's former career, because she was an engineer, was that she worked on an oil rig in the Gulf of Mexico. There we go. Worked on an oil rig in the Gulf of Mexico. And if those people got the look that I just got, I'm sure they were always falling in line. So, but Delaney has been doing the open records, piece. She is entertaining and she is going to hit me. So, Delaney Brewer.
All right, excuse my, for an engineer, I know nothing about technology when it comes to computers, but do you have the right names up there yet?
One more.
There we go. So that's us. Well, I'm glad to see so many people made it back after lunch. That means we're doing something right here. So our panel is, we put the most entertaining panel after lunch. We are going to talk about costs. So open and transparent government is an amazing and wonderful thing until you get the bill in the mail. And the question is sort of who pays how much and how can we collectively sort of bring down the costs of making, you know, the government open and transparent. So I'm going to give you a quick introduction to our panelists here. First is Jamie Aulick. He is the county clerk of Manitowoc County. He has a very impressive resume here, mainly because he has been an Army reservist for 18 years and is an Iraq war veteran. Yeah. And he has the rank of Sergeant First Class, and probably even more impressive, he has 4 children.
6 and under.
Yes. Wow.
It's a nut house.
Yeah, a nut house.
I guess.
So Jamie has served as the Manitowoc County Clerk for 8 years, and he chairs the Legislative Committee and the Website and Publicity Committee for the Wisconsin County Clerks Association. Also on our panel is Stacy. So Stacy Hoffman is, she also has a very impressive resume and a lot of experience in this area. She is the president of the Wisconsin Register of Deeds Association, past co-chair of the Legislative Committee, chair of the E-Records Committee, a member of the Archives and Backup Committee, and has been working on these sort of issues for sort of small government for a long time. She was appointed to the Wisconsin Counties Association Board of Directors in 2014 and is a member of the Wisconsin County Constitutional Officers and is a member of the Wisconsin President's Council. So Jamie is a Register of Deeds of Jefferson County. I'm sorry, Stacy. Yep, thank you. And thirdly, we have Bill, and Bill Leaders is the president of the Freedom of Information Council, and someone attends on behalf of the AG's office pretty regularly these Freedom of Information Council meetings, which are very valuable for everybody who attends. He's the associate editor of the Progressive magazine. He previously worked at the Isthmus, and if you are at all familiar with open government issues or the press in and around Madison, you probably already know a lot about Bill. So with that, I am going to let Jamie start the show here. I think you should be all queued up.
Great. Yep, hey, that's me. All right. Well, I do have the unenviable charge of talking about the cost of open government. So first, I'd like to thank the Attorney General for holding this. We had a small group of clerks in attendance, and we were saying things like this ought to be more frequent, certainly. And this is really great to see this type of summit being held in our state And these are really important issues. There's a lot of stakeholders obviously involved in these types of things. So really do appreciate the opportunity to come and speak about the cost of open government. We talked a little bit earlier in the day about the seminal year 1981, and one of the gentlemen who is presenting the speaker said that he was in first grade, and I think I have everyone beat. I was in diapers, but anyway, I was 1 year old in 1981, and I had to do a lot of studying to make sure that I was prepared for this type of presentation. And so to start off, let's see here. First, I'd like to make the point that local units of government, people like myself, we really do take a lot of pride in being open. In fact, we take so much pride in Manitowoc County. You can call my cell phone number night or day, 920-9. No, just kidding. Not going to do a Lindsey Graham there on the phone number, but anyway, we do take a lot of pride in being open. You know, when you're a local elected official like myself, there's no spokesman for the office. You know, a lot of times I'll look at what happens at the federal government or other levels of government, and there's actually like PIOs, public information officers, various people who are in charge of being the spokesman. Well, I directly interact with the press. I directly interact with the customers. In our office, county clerk's offices in Manitowoc County, we do 450 marriage licenses every year for mostly happy couples. Not everyone is happy to get married, but nevertheless, I enjoy that personal interaction as a local official in interacting with the media and the public. And, you know, also, when you think about it, for someone who is elected, we are, every 4 years in my particular case, going to be dealing with the same media and the same public if and when there would be a competitive election for my office. So it's a very direct kind of connection that we have with our constituencies, and we take a lot of pride in having good relations with them. Also, we are records custodians. I think, is it still true that Wisconsin has like 1/5 of all the elected officials in the country, I think, are housed in our state, something like that. And all of them in state law are records custodians. So each local elected official, each county board member, each school board member is actually a records custodian. And again, that really ties you down to, hey, you guys are paying the bills for what I do on a daily basis. Really want to make sure that you have access, and that's where the third point comes in, to your local government. You're paying the bills for this, and we understand that, certainly at the local level, and we want to make sure that people are involved in their government. And there was a point earlier, one of the presenters had made, that there is unfortunately apathy towards what happens at the local level. Each time that I develop a ballot for my county, we're in charge of developing ballots for Manitowoc County in my office, and I see the word vacant next to an oval, that's not a good thing, right? So we want to make sure that we're encouraging people to be involved in their government, and even, you know, public records is a good way, good customer service way of working with people when things come up. So for local, what I'm really emphasizing on this one, we talked about law enforcement offices earlier in the day. You know, our sheriff's department, I think, has about 100 employees. What I'm referring to here now is the 1 or 2 or 3 person operations that you see in a lot of the different offices that we have throughout our state. And so, you know, I got to say, with some of the things that we work with in the county clerk's office, with marriage licenses, with election records and things like that, you know, dealing with some of the constituent things that we deal with. Sometimes I look at my computer, my email program, and I kind of cover my eyes, and then I look through my cracks in my finger and try to read the email if they're yelling at me or something like that. Public records requests are not one of those types of things. And I got to say, at the local level, when we work with the Herald Times in Manitowoc, or if we work with the various weeklies that we have in our county, excellent working relationship. I can pick up the phone, call that reporter and say, well, let's clarify on what you're talking about. So, but at the same time, I'm out of the office speaking here to you folks today. We're short-staffed. That's one person, that's 1/3 of our office is out right now. And so, and a lot of county clerk offices, I can't speak for registered deeds, but I'm pretty sure that in some of the smaller counties, it is a full-time elected official, and some cases, especially in smaller counties, sometimes you're lucky to have a part-time deputy. So I know in one particular county, for county clerks, there is a county clerk, and the deputy is part-time, comes in Monday, Tuesday, Wednesday. And so you got to work around those types of issues. So staffing has always been and continues to be a challenge as we deal with public records requests. So first thing I want to emphasize is we're trying to do a large balancing act when we get public records requests. One of them, especially the public rights to know versus protecting the integrity of the record. I have a poll list from 1838 in my office, has 27 people with their names signed on the poll list, and fountain pen or quill pen, inkwell style writing, and that would be something that I would be hesitant, obviously, to shove on the photocopier and make a copy of, right? So making sure that we're protecting the integrity of the records we're charged with is extremely important. And I don't know what voter turnout was at the time for 27 people who showed up, but anyway, that's what I have for 1839 anyway. And also, the integrity of the record is really important too when it comes to ballots. I'm going to get into a little bit of a case study here, but if you're talking about pieces of paper that people have voted on, you don't want to just hand that over to just anyone, right? All of a sudden they could be marking and erasing and things like that. So you really need to be conscientious and monitor those types of inspections if they crop up. So again, you want to make sure that you're protecting the integrity of that record. The public rights to know versus confidentiality. I had in the February primary, a school district who had a board member primary in the northern part of my county. And so if you know anything about how school districts work and their districting, it's called parcel-based, meaning the person on this side of the street could be going to one school district, and then the next address over, same side of the street, going to the next one, right? Well, how it works is if you have a town that has a poll location, most of my towns are squares, one poll location, and then the school district just grabs a couple of people and then peels them off into their school district. Those 3 people, I do have a school district in my county that has 3 registered voters in my county. What does that mean? That means their ballot has that school district's office on it, and the rest of the town has a different school district on it. What does that mean when you're doing a recount or opening up that ballot bag? That means if they showed up and voted, you know exactly who those people are, right? It's that one household. Just so happens, in that February 2015 primary, we had in an entire town a couple walk in one of those school districts and vote, and they were the only 2 people that entire day to walk into that poll location. Only 2 people, and they only came in because they were reminded the day prior, the Monday before Election Day, town clerk just so happened to see them. Hey, Linda and Jerry, you coming in tomorrow? And they were like, what? So all of a sudden, you have a couple, 2 people in a ballot bag, and that's what you got. So such as that goes. We want to make sure, though, that we're providing our confidentiality, right? So public right to know versus confidentiality. For certain records, it's important, I think, that we all have a presumption of privacy, right? When we vote, we want to make sure that we maintain those types of things. And lastly, another concern that we have, this kind of goes back to how our public records law works. It's excellent that we are probably the sunshine state in the country, right? We do an excellent job with our public records law, and we're obviously here trying to modernize it. But one of the things too that we deal with is the fact that people from other states can come in with their own kind of agendas and make hay and use of our very open public records law. And one of the things that had cropped up is that there is a group who does not trust electronic tabulators at all. They think on some level that every 12th vote is altered. It's counted for the opposite person. They can be hacked and things like that, okay? And in this particular case, there was a public records request from Ohio. That's where this lady was from. She had organized people in Wisconsin to help her out. But anyway, while we're trying to deal with those types of things, we also need to make sure, and this by the way is versus the customer service responsibility to the residents the office serves. So that's all kind of one sentence. We want to make sure that we're taking care of our residents first. You can't just be in the middle of doing a hand count audit of ballots and say, hey buddy, I got to go over here and do this marriage license that just walked through the door. You know, we got to somehow figure out or prioritize or balance, of course, our responsibilities to our customers, because we are a direct service office, versus, you know, considerations that come in from outside of that. So anyway, here talking about a little bit about the ballot audits, kind of to set this up. It was only for electronically tabulated ballots. It was made to a number of county clerk offices throughout the state of Wisconsin. And they traveled from office to office. Now, I'm going to take you back to 2012, if any of you remember 2012. We had 6 elections in a 4-election year in 2012. That 2012, and of course, in county clerk's offices, we were extremely busy dealing with an election every other month. So that's when this came into the mix. And so right after the recall election on June 5th, 2012, this is where this group started making these records requests. Of course, everybody is allowed to come in and inspect records. The GAB provided guidance that no one other than elected officials were to touch the ballots. Now, they wanted to come in, they wanted to set aside the stacks of ballots that we had from the recall election, and then they wanted to hand count them to verify them against the totals that were on the tabulator. So that's what's going on here. And only election officials could touch the ballots per GAB, per the Government Accountability Board guidance. Again, you don't want people marking them, erasing, or what have you, so that's the reason behind it. And so that's what ended up happening is staffs throughout the state ended up flipping over ballots while they had their clickers. They had like little like ticket taker kind of clickers. And, you know, one person would be standing on one side, one on the other, and then the election official in the middle would be flipping over these ballots. Well, in Racine County, here's kind of a little case study. They spent 57.25 hours in a room with those people flipping over the ballots. And so it doesn't include the time spent assembling, organizing, moving the materials. Remember, these ballots are secured, at least in most cases, in a vault area. So you have to move them to a room where you can accommodate the request, and then there's scheduling, both within the office and also with the people who are hand counting them, trying to get enough people to come in, and other preparations to fulfill the request. It took 10 weeks to complete, and because of the arrangements of the time, and of course balancing that with the workload. And then we talk about, for the staff time, it was $31.25 an hour, and they spent $17.8906. And again, it doesn't include the preparation time, other supplies, and that type of thing. So that's what their particular experience was with citizen audits of ballots, is what they called it. A couple other things that we really are looking for clarification on. Does an electronic version of a record necessarily follow the same disclosure laws as the record itself? This is about modernizing our public records law, right? One of the things that clerks now are encountering as we modernize our tabulating system, so where your ballot goes into the tabulator on election day, one of the things that happens it's single digits yet for counties, but they're actually able to scan the front or each side of the ballot as it goes through into the ballot bin. It's scanned. And so it's kept on a removable memory device, a storage, like a USB stick, so to speak. And as the ballots go through, they're actually randomized on the stick, so you can't necessarily trace it back to the voter. But nevertheless, are those ballots disclosable? Is the flash drive disclosable by the period of a recount ending? So can you send out the memory device prior to the ballots being able to be opened out of that ballot bag? So we have a paper record, right, with the ballot and the electronic one. Do these two follow the same rules? That's what we're looking to get clarified specifically. Another thing that a lot of units of government encounter are scanning and emailing things. I think there's a perception out there that if you get it electronically, it should be free. And I don't necessarily know that that is or should be the case. It certainly is sometimes when you get I know councils a lot of times will advise someone like me that you can charge for those types of things, but it would be nice to have that in black and white, that electronic versions of records are also, cost the same 25 cents or whatever it is as the paper version of the document. And lastly, what's the responsibility and authority when a requester requires uploading documents? I know a lot of different units of government, especially if you do anything with accounts payable or finance, you get requests from companies for you to upload your information into a system. And sometimes that'll require a little bit of formatting or reformatting or things like that. Now, some companies are good about it and some are, please remove this column, that column, and et cetera. But there is that out there that a lot of times the uploading of documents are going to be, that's just something we'd like clarified as well, if we modify them at all or anything like that. So along with that, I guess that's all I have for this morning, or this afternoon. All right. Thank you very much.
All right. Well, first of all, I want to thank A.G. Schimel and his staff for having us here because we really want to be part of this. As a Registered Deeds Association, we want to be proactive instead of reactive to things. So thank you for inviting us and letting us participate. As you can tell by my bio, I am not an attorney. I don't have a political science degree. I am just simply the girl in the office doing the work. And I'm also the department head who has to try to balance the budget. So that's what we're going to try to focus on a little bit today. So contrary to popular belief, our goals include transparent government. We want to assist our constituents. We want to fulfill our requests in a timely manner. We don't want to hold anybody off and make them wait for weeks and months. That's not our goal. We want to be helpful and not a hindrance. And we need to be fiscally responsible to our taxpayers. As you know, through all the economic times that we have right now, we do have tightened budgets. And most counties are asked to do more with less funding. We've been trying to do things through lean processes, and I know people who work for government are sick of hearing lean because everybody wants us to do more and find better ways to do it. But we are trying to do things, and this could possibly be a great lean event, so hopefully we can do something with that. So during these economic times, we've been asked to reduce our staff either through layoffs or through attrition, so we have less staff to do the work that we have to do on a daily basis. And for the Register of Deeds office, most of our duties are statutory. So we don't have a choice on what we want to do. We follow statutes. We do what we're supposed to do statute-wise. Open records requests have created new positions for counties. They've created overtime and they've created comp time. So there is a financial cost to having open records. So the one thing that our Sheriff's Department has asked me to talk about, what comes first? Do I do the open records request that everybody wants, because they all want it and they all want it now, or do I do my daily duties? I guess that's something we have to figure out. So there is a real cost to providing open records. We have our staff time. We have additional IT costs. There's additional hardware and software that's required to fulfill these records requests. There's additional allocated costs, and I know people talk about you can't count allocated costs, but that's a reality. We all get charged money to have people in our office. So even though you don't want to talk about that, it is a reality. We do have to have risk management, and that comes at a cost. And of course, there's increased records retention policy fees that we have to discuss, such as the document, the emails, the Facebook, Twitter, social media, dash cams, body cams. We've talked about all that already this morning, but these are things that are real, and we need to figure out how to deal with them at the government level. In Jefferson County alone, we've decided we are keeping our emails for 7 years. We did have to purchase an additional server just to store those, because there's a ton of emails. That's a lot of money to, you know, spend that we don't really have. So, then we're going to talk about redaction. Now, I know we can't charge to redact things. I don't understand why that's in the statute. I think that's foolish. It does cost a lot of money to do it. There's federal and state laws that tell us we have to redact things, and so we have to follow them. Obviously, HIPAA is a part of it, anything that has to do with health or medicines. We have juvenile information that has to be redacted from public records requests. Of course, social security numbers, nobody wants that out there. Some people want financial account information redacted. And then informant identification is all redacted. So anything that might have a name, an address, a telephone number, an email, handwriting sample, a voice sample that an informant might provide, that should be redacted from public record. So I just want to give you an example of something that's going on in Jefferson County. There is a request for a 20-year-old death record, and this is from a media outlet. I don't really know that this, in my opinion, should fall under open records request, because they're going to do a story about it. So they're going to benefit at some point from it. It's not doing anything for public right now. So in my opinion, I don't really feel this falls under that type of request. But it is a court report that consists of 778 pages. There's 38 juveniles involved in it that are listed in it. But then there's other names that are in there that they're going to have to redact out. There's medical conditions for some of the people involved, and there's medicines that need to be redacted. There's 63 videos, VHS videos, that were taken during this crime investigation. And as you know, most people don't have VHS anymore, so we do have to transfer them onto a CD or DVD, so we had to manipulate the form of it. And then, from what I understand, they have to take the video, redact the video separate from the audio. I don't really understand why. Like I said, I'm not an expert on all this, but these are the things that people have asked me to talk about. There's additional cost to do this. So they also have to go through dispatch records. There's software that they had to buy to be able to do this, and which helped a little bit with some of the redaction, but the majority of it is still manual. A month has been spent on this already, and so far they're estimating that there'll probably be 3 or 4 more months involved in fulfilling this one request. In the meantime, there's hundreds of other cases that they get. So this is just an average monthly workload that the Sheriff's Department provided me. And let me just grab my notes here, because I wanted to tell you about how much time they spend on each one. So their standard accident reports, they had 77 last month. They spend 10 to 15 minutes per request on that. There was 80 contact history reports, and those take anywhere from 5 to 15 minutes. There was 2 family court reports requested, and they have to go back 10 years on this. So this is one of those things where we're talking about how long do we retain these records. They had to go back 10 years on it, which take anywhere from 2 to 40 hours per request. The county district attorney had 15 requests, which each one they spend about an hour on. The average non-incident accident reports, there was 20 of them, and they take about 1 to 8 hours per request. There was 55 complex reports, which take anywhere from 80 to 40 hours per request. And there was 4 medical reports. These come from Social Security, some attorneys, some insurance companies, and they take anywhere from a half hour to 12 hours per request. And then we have this one challenging one that's going to take several months, and now I just found out there's a second one that they would like from an old murder case. So as you can see, they had 254 requests. This is just an average month, plus these other things that are going on. So what does this cost the county? We had to take our secretary that was at, receptionist at the front desk in the sheriff's department. She used to do part-time. She would spend on just working at the desk, and the other part of the time she'd spend on open records requests. Well, there's so many of them that there's no way she could handle it all. So we had to create her position as a full-time open records request clerk, which costs the county $63,800 per year. That's going to go on forever as long as people are asking for open records. We took the part-time receptionist. She's doing that half-time, and she's also helping with open records because the one girl can't complete it all. So that's about $31,900 per year. And then this year, because we had this exceptional case, we've also brought in another staff member. They're figuring about $5,000 she will be spending on it. So that's $100,700 that Jefferson County will be spending on open records requests in staff time alone. That's just staff time. That does not include all the other allocations that are involved in it. So we have IT allocations in our county. So every computer printer that's hooked up to our server, we each, in our departments, each get charged $1,100 for each item that's hooked up to there. So that's to make our IT department stay off the tax levy, but it just pushes it on to another department. We have indirect costs, and I know people say you can't charge indirect costs, but the Sheriff's Department spends $922,000 a year on indirect costs. Now, if you wanted to break that up per person that works there, I'm not sure how you want to do it, but it is an actual cost that the Sheriff's Department has. And one of those people, or actually three of those people right now, are part of that indirect cost. So obviously, like I said, we had to buy special hardware, extra computers, extra monitors, extra printers, extra office equipment, just to staff this. And then, of course, there's the redaction software. And as any of you who know, who's bought software, there is an annual maintenance fee that goes along with it. So it's not just a one-time fee that we bought the software, it's done and good. We pay that annual fee for forever, or until we get a new program. So those are the costs from the Sheriff's Department. I would be remiss if I didn't mention the Register of Deeds office, because the Register of Deeds was able to work with A.G. Schimel, and we brought up some concerns that we had. So here are some of our concerns, and I know this is kind of talked about a little bit earlier, but data harvesting. The Register of Deeds is the custodian of all land records, and we also have vital records in our office. We take this responsibility very seriously. We want to ensure that with the advent of technology, that we're providing access to these records, and the records are not allowed to be harvested and sold. Maintaining the integrity of our records has been an important function since 1840, and we want to continue that. Redaction of personal information. A few years back, the legislature was happy enough or nice enough to provide some funding for us. With every document that was recorded, we took $5 of that recording fee and redacted Social Security numbers out of all the records that are available online in the Register of Deeds office. Jefferson County alone spent $44,000 doing that. That was great. Social Security numbers are done. That $5 money that we got now is gone and is going to another state-funded program. What happens when somebody decides that they want to have something else redacted? I don't want my account numbers out there. There's phone numbers on some of those records. There's all kinds of personal information in the records that we hold in our office. And who decides when they want to redact that? How do we pay for it? So that's a concern of ours. We have statutory fees, so we're lucky enough in our office, we know what we're going to charge for everything. Not every department has that, and we just want to make sure that our statutory fees stay statutory fees. If people don't decide they think that everything should be free and given to them, you know, because we work for government. Uniform fees. The one thing that we don't have a statutory fee on is report requests. So if somebody wants a report out of our office, it's kind of up to our counties how they set that fee. Our county believes that it should be $1 a page for the request because we have to create the request. Some counties believe that certain reports are only 25 cents a page. Well, you may be spending an hour on creating that, and we're only going to charge 25 cents. I don't think that's fair to the taxpayer. So the other thing that we want to do is make sure there's no property fraud. We touched on this a little bit earlier. We want to make sure that the information that we have is secure. We don't want anybody coming into our offices and stealing your ID. You know, we want to make sure that if you have property and something is recorded against your property, that you know about it. So there's software out there that can do that, but there is a fee for that. In Jefferson County alone, if I'm looking at possibly purchasing a new system, it's $160,000 to purchase it, and it'll be a $19,000 per year fee to maintain it. But we're doing it to help you. And, you know, how do we manage all that? Let's see if there's anything else. So here's my last slide. Reimbursement. Who should pay for it? Should the taxpayer pay for a request through an increased tax levy? Well, you all know that we have a zero tax levy increase, and that's been that way for years. So how do we take care of it? What services are we willing to give up so that we can provide this information for free to anyone who asks for it? Should the requester pay the actual costs? In my opinion, if you want something, you should pay for it and what it costs to produce it. And so now we have to decide, what does it cost to produce it? So how do you calculate those actual costs? One of the questions I believe Bill maybe even asked me is, should the payment be made up front? In the Register of Deeds office, we make people pay up front. It's actually right in the statute that you pay for your record up front. But that's not in every department. And how do we determine what the actual fee is if we make them pay up front? But then again, how do we ever collect that 25 cents? You can't bill somebody for 25 cents or 50 cents. So we have to figure out a way to handle that. Should there be standardized fees for these requests? Should there be standardized formats? What about the statutory fees? Should they be updated? Does that 25% per page still hold true? Now, I'm not going to quote myself on this, so is that since 1981? I know you're in diapers. I graduated from high school in 1981. I don't know. Things changed since when I was in high school. So the fees probably need to be looked at. So with that all said, that's really all I have. And I just want to thank you again for, giving us this opportunity and to get this discussion started. And anything that our association can do to help out with this, we're right there for you.
So I'd also like to thank AG Schimel and his staff for putting this event together, and to all of you for coming. I represent the Wisconsin Freedom of Information Council, which is a statewide group that works to protect public access to meetings and records. We have about 24 members representing media, academia, interest groups, and we track what happens in terms of our open records and open meetings law, changes that happen as a result of legislation or attempted legislation, changes that happen because of court decisions and court battles, and changes that happen in practice that custodians just start doing things a certain way that we need to be mindful of. It's always been my belief, and I think the belief of the council, that open records and open government benefits not just the citizens of the state, but the government as well. That it's one of the ways that government officials build trust with the people that they represent. The more openness, the better they look. By and large, when you see what goes into the making of law and policy, when you see how public officials conduct themselves, they look good. It should be recognized as being fundamentally in the interest of the custodian as well as the requester. When it comes to the issue of cost, or a related issue that I would cite, that of the long delays that requesters sometimes experience, I am drawn back to the Declaration of Policy, which prefaces our open records law, and some other speakers have referred to it. I'll want to read you the part of it that I think is on point. It says, of course, it's declared to be the public policy of the state that all persons are entitled to the greatest possible information regarding the affairs of government. Moreover, it says, providing persons with such information is declared to be an essential function of a representative government and an integral part of the routine duties of officers and employees whose responsibility it is to provide such information. So when we talk about cost, when we talk about time, my position is that public officials, public offices are already charged with providing information as a fundamental responsibility. It's not something that, generally speaking, they should be able to charge extra for. The law does allow charges in a certain narrow range. It does not allow charges for everything, and that's for a good reason. Let's review what you can charge for. You can charge for the actual necessary and direct cost of making copies. You can charge for the actual necessary and direct cost of mailing a record, and you can charge for the actual necessary and direct cost of locating a record if that cost is over $50. People have spoken about inflation. That standard, that $50 standard for location fees was part of the law when it passed in 1981. Just adjusted for inflation by the Consumer Price Index, we're now, that $50 in 1981 would be $131 today. The original intention of the legislature was to give citizens somewhere about $131 in current dollars in free location costs before you start to charge. If we change anything about our open records law with regard to the question of cost, that's what I would like to see changed. I'd like to see that threshold be raised to bring it into the modern age. I encounter people who come to me all the time with concerns about cost, more often delays. I think delays are frankly a bigger issue in Wisconsin than cost, in part because of this decision that was rendered by our Wisconsin Supreme Court a couple of years ago, which said that no custodians may not charge for the time that they spend looking over records and deciding what they're going to black out. I think if we allow those charges, we are going to invite abuse. We're going to create a mechanism that any records custodian can use to very quickly make records unaffordable. By charging the cost of having their lawyers, for instance, review these records and decide where they're going to put the black ink. But now that the Supreme Court has dealt with that, I think cost is a little bit less of an issue. I hear from people, though, who don't want to pay anything. And, we have to tell them that, the law does require some, and there's things you can do that will minimize the amount of time that it will take the custodian to fulfill your request and thereby reduce the amount of expense that you may have to bear. Those are things that we encourage people to do. We encourage people to invite a dialogue with the custodian. In fact, the Open Records request letter template that we have on our website has that explicitly. It says, if I can clarify or refine this request, please let me know. Right from the outset, we encourage people to invite discussion with the custodian so they can come back and say, well, what do you really want? Or they can come back and say, well, this is a lot of work. What can we do to make it more manageable? And those type of negotiations are successful, and they do reduce the burden on custodians. They do reduce the cost. Another problem we sometimes see with specific regard to cost is this claim that to do a keyword search is going to take like this huge amount of time, and I don't understand where that comes from, and I don't think it's always valid. I can crack open my laptop right now and I can do a keyword search, say for Brad Schimel, and I can find every email I've sent or received that has his name, and it will happen in about 15 seconds. So when I see someone who's gotten a response from a custodian to a request for emails that they want to find through a keyword search, and they say it's going to take at least 40 hours and cost you at least $2,000, I really wonder what's going on there, whether there's good faith in that type of response. The cost of copies is not set by statute. The cost of copies is something that the Attorney General in the compliance guide has addressed somewhat. It says that, generally speaking, 15 cents per page would be considered a reasonable cost. Anything more than 25 cents a page would be suspect. I have seen cases where people charge 30 cents a page. I've seen cases where they've charged 50 cents and even a dollar. And under our last Attorney General, J.B. Van Hollen, there were a couple of occasions where when I called those situations or those charges to the attention of the office, they basically called the custodian and told them to knock it off, that you shouldn't be asking for this much money in order to provide a record. I want to share with you, this is an example of a type of situation that people come to me with. The other day I heard from a writer. He was trying to get information about the Milwaukee Bucks arena deal, and so he made a request for records from a City of Milwaukee agency for all of the records of communications involving the Milwaukee Bucks Arena for a very narrow period of time. It was from May 1st of this year through mid-July when he made the request. The agency director said this would take just a huge amount of time to provide these records, offered to do 1 hour of location time for free, and thereafter charge the requester at her salaried compensation rate of $51.87 an hour. So I got back to the writer who brought this to my attention. I said, there were several things you can do. You can ask for an exemption from the charge altogether by saying that the release of this information is in the public interest. There's a provision in the statute that you can ask for either a waiver of the fee altogether or a reduction of the fee if it is in the public interest that this information come out. You can remind the custodian that according to our Attorney General and that compliance guide that generally the rate for the actual necessary and direct charge for staff time should be based on the pay rate of the lowest paid employee capable of performing the task. Now, someone who makes $51.87 an hour is getting paid $107,000 a year. I doubt that's the lowest paid person in the office. That's why I point out. I said also the requester, and you can offer to work with the custodian to try to narrow the request. Well, this is the response. The custodian in this case came back and said, unfortunately, in this case, there are no other parties who are capable of locating the records. I'm the only person who has access to this information and can do the search. Well, I'd submit that if you haven't arranged your office sensibly enough that someone else besides the top person can locate records in response to requests, maybe you shouldn't be making $52 an hour. With regard to the request for waiver of fees, this was the response. I believe all records requests are in the public interest. That's why I've developed a policy that I apply consistently. In other words, everybody pays. I will interpret the statutory language that tells me I can waive a fee if it's in the public interest as affirming my decision to charge everybody. The third thing did work, though. The writer was able to negotiate with this custodian for a narrower range of records and was able to obtain information much more quickly, and I think at no expense or at a very nominal expense, just the copy cost and not the location fee. So again, I think it comes down to, first of all, asserting that the public has a right to this information. It's not something that they should be charged extra for at every turn. But they also have an obligation to work with the custodian to narrow the request if possible, to be sensible about the request, to be respectful about the demands that they put on the custodian's time, and to try to interact and negotiate a better result when possible. That's pretty much all I have.
All right, thank you, panelists. We have just a few minutes left for questions, and I'll start with one because I want to tie this back into the earlier conversation about technological changes. So the question is, has technology increased or decreased the cost of responding to open records requests? Obviously, we have new software and new hardware, but we also have more records because we have emails. We have an easier method of transmitting records, but again, we have to then search a larger database. So if changes are made to the law regarding technological changes, should there be corresponding changes relating to the cost of responding to records?
Sure. I think, at least at the local level, it's kind of been a wash. When I first got elected county clerk, one of the first things I did is post election results on the county website for the department. I mean, kind of scanned and took a look at the various requests that we get and tried to make it as easy as possible to find. So election records, marriage license brochures, things like that immediately went on to the website. Now, along with that, as we continue down the road of, especially in the area of elections, getting more and more technology based. I mean, there's discussions right now about whether or not we should have electronic poll books at the polls here in Wisconsin. So instead of, stating your name and address and the poll worker looking through reams of paper, you could, scan your driver's license, all of a sudden your voter record information crops up, sign the iPad or whatever it is, onward, upward, you get your ballot, keep going. So along with that, of course, is going to be how do we query the information out of the iPad, what's it retained for, things like that. So, at least from my perspective, it's kind of been a wash, and absolutely as clear as we can make the guidance on what's able to be charged for electronic records. One of the things I alluded to in my presentation is, I think there's a presumption sometimes that electronic scans of records should be free. Making things like that explicit in statute in particular, would be extremely helpful. So yeah, as clear as we can make some of these things, that's absolutely, and then, from a records custodian point of view, we could just refer back to the law. Here, citizen X, this is what our reference is. It just makes things a lot easier. Thanks.
Well, I'll just say as far as the IT people at Jefferson County, that's who I talked to, so it's going to be a lot of Jefferson County stuff. The more stuff that you put onto the internet or onto an electronic database of some sort, the higher the cost is for it, not just to put the records there, but to maintain it and to secure it. We don't want to be hacked. Everybody wants their information secure and private. I know that some of the stuff is open records, but you still have to protect what's there, and there is a cost to that. So yes, electronic records do make it easier for some things, but it does tend to make it more expensive to get the record there and to maintain it and to secure it.
The changes that we support in terms of new technology are all either cost neutral or perhaps would save money for custodians. We would like to ban electronic chatter at meetings so that the participants at a public meeting cannot be communicating with each other by laptop, instant messages, things like that, and instead of discussing their positions openly. We'd like to require the use of government email accounts for official business, so public officials are not conducting the government's business on their private email accounts. We'd like to create standards for the retention of these records and so that we preserve these electronic communications for the future. Again, having a data bank might actually make it easier to locate and retrieve these records and provide them at a nominal cost. With regard to the open meetings law, we would advocate a very simple, low-cost requirement, which would do a world of good. Require that when a public body go into closed meeting, they turn on a tape recorder. They keep a record of that proceeding. If there's later a concern raised about whether they strayed from the issue that they said they needed to go into closed meeting for, any concern about the legality of it, there would be a process where someone could petition for judicial review in camera of that recording to see whether the law was followed. Very simple, very cheap, very effective, and it would make a world of good.
Well, we do have just a few minutes if anyone has one question from the audience, and if not, we can wrap up. Is there anything? There's a question over here tonight. Do we have a run-in?
Audie's running. He's coming. Where is it?
Hi, I'm Mary Batari from the Center for Media and Democracy, and I have a question about texting, which I've been doing while we've been having this conversation today. We know for a fact that a lot of our most esteemed policymakers are making a lot of decisions by text. I was wondering if Bill could address the issue. They're not regularly giving up their text. They're not giving up their text even when specifically asked. So I was wondering if someone could address that.
Well, first of all, I'd like to make open records request for the text that you sent during this meeting. If a text is preservable, it should be preserved and it should be provided. There are some, I don't know if it's instant messages or for instance, are sometimes not retained. The city of Madison, Roger Allen, who was here, did develop a policy some years ago which said that if the technology isn't there for easy retention of communications, public officials shouldn't be using them for official communications. That's simple. But if it is retainable, if you can simply download your text messages into an archive and save it just like your emails, or for instance, have your text sent to you as an email and then make it archive it, that's what they should do. So I think it's a very simple solution. If it's something you can preserve, you should preserve it. If it's something that fades away like a voice communication, you shouldn't be doing it. You shouldn't be using that form of communication.
Okay, well, right before we wrap up, I just want to add that you all have an evaluation in your folder of today's summit, and we'd love to get some feedback on what you think. And obviously, you all are expected to stay around and not go put your blankets out this afternoon. So we'll see you all at the next panel, certainly. But just a reminder that I believe there's going to be a box in the back to drop those, and we'd love to hear your thoughts on today's summit and anything else about open government you want to add. So with that, a big thank you to our panelists.
Thank you very much, Delaney. Thank you, everybody, for being here. And thank you to all of you again. We can't say it enough times how much we appreciate you all being here today. As Delaney said, please complete those surveys. We do have a box outside. Your feedback is important. Maybe this will become an annual affair. We would really like to know what your thoughts were about today. We're going to take a quick break. We'll break for a few minutes and come back at 2:30. And that will be the end of at the end of our day after that. So at 2:30, come on back. Thank you.
no such thing as bad exposure. I mean, the more the better. That's the way.
Well, yeah.
There you go.
All right, everybody, can we get you to take your seats? We are on the home stretch here. One more reminder, thank you if you filled out your survey. We would like to get your thoughts on the event, so please fill out that survey and you can put it in the box that's outside on the desk where you registered. Our next panel is Wisconsin's Open Meetings Law Overview and Discussion. And I want to introduce you to the administrator for the Wisconsin DOJ Division of Legal Services, Dave Meany.
Thank you. Thank you, Annie, and thank you. And in particular, I want to thank you for your continued presence here at the last session of the day. I think it reflects the importance of all the issues we have been addressing here at the summit, and hopefully, and particularly, our final topic, our open meetings law. First off, I'm not going to address the issue of where I was in 1981. That's what we lawyers would call an admission against interest, so I won't go there. As far as my background, I just wanted to mention that I've been on both sides of the issues that have been discussed today, both in private practice and then as Chief Legal Counsel at DATCAP, and now in my position at the Department of Justice. So I have been both a requester and one who has fought out open meetings issues and public records issues, and also been responsible as a records custodian for responding and providing advice on open meetings over at DATCAP. Let me introduce our panel. We have a distinguished panel here today to address open meetings issues, both distinguished and experienced. I will provide a brief introduction in the order that they will speak. First off, we have Andy Phillips. Andy is a partner at the Milwaukee firm of Von Briesen and Roper. He's had a long career assisting local governments and school districts and businesses, including issues relating to public records and open meetings. He has served, I believe is still serving, Andy, as general counsel for the Wisconsin Counties Association, obviously a position that involves the issues we're here for today. He also has a litigation background, an extensive litigation background in all forums and many venues. Lastly, I'd like to mention that Andy does have a significant public interest participation. You'll see on his brief resume that he has served on the board of directors for the Angel on My Shoulder group, and also serves as a commissioner of a public body for which I'm sure he is giving good advice on open meetings for the Cedarburg Police and Fire Commission. Next we have Chris Hardy. I'm going to save the best for Chris for last, because I'm very jealous of his current occupation as a B&B operator in rural Jackson County. Chris is the executive director presently of the Black River Area Chamber of Commerce. He assumed that position after a long career in the media. He was executive editor of the La Crosse Tribune and publisher of the River Valley Newspaper Group's weekly division, which included, I believe, 2 local papers, Chris, the Toma Journal and the Jackson County Chronicle. In addition to that experience, Chris has excelled as measured by being the recipient of nearly 24 state and national journalism awards, including a nomination for a Pulitzer Prize in the area of his reporting on stray voltage issues. He is a former member of the Wisconsin Freedom of Information Council and past president of the Wisconsin Newspapers Association. And finally, we have today Chief Counsel at the Public Service Commission, Cindy Smith. I can speak from experience as being a partner in private practice for many years with Cindy that she is a very accomplished attorney in private practice in the environmental area and as a litigator. And she has been at the Public Service Commission as Chief Counsel since 2004. Cindy? Excuse me? 2010. Okay, I apologize for that. I thought you were there earlier. Cindy was, as I mentioned, in private practice for 17 years prior to that. So with those introductions, I will turn it over first to Andy to speak on some issues that he thinks have particular relevance in the open meetings area.
Thank you, David. Good afternoon. As mentioned, I'm counsel for the Counties Association. I've worked with them for 20 years. I've worked with local governments and school districts for about 20 years, primarily counties and schools. And so my perspective on this is one that, what are the questions and issues that come to me on a seemingly daily basis dealing with open meetings issues? What are some of the issues that have been litigated out there, and what are some opportunities for what we see as needed updates or necessary updates in the law to try to capture what really happens today as it relates to open meetings and local government compliance with open meetings law. So let me start by making everybody exercise first. All right, put your hand in the air if you are an employee, official of, or affiliated with local government, if you could. All right, a lot of folks, keep your hands in the air. How many of you with your hands in the air do not believe in open and transparent government? We got one. We got one. All right, that's the first one I have ever seen in my career where somebody affiliated with local government says, hey, we don't like transparency. We are anti-transparency. Every single client I talk to, every single municipal official I talk to, every single school district official I talk to says, we are fully supportive of an open and transparent process. That's the Wisconsin way. So why is it that we ever have a dispute about open meetings law? If that's the case, because I'm quite sure that our friends on the press side, as Chris is going to talk about, I'm quite sure that our friends on the public side, that others today have talked about, fully believe in open and transparent government. So if everybody's on the same page there, why do we ever get into a dispute? Well, I'll talk a little bit about where I think some of the issues come from. And in the first case, sometimes it's just not politically expedient to have an open and transparent government. And we heard that mentioned this morning in the discussion, that sometimes politics gets in the way of an open and transparent environment in which we conduct our governmental business. That's entirely true. Sometimes we run into practical problems as it relates to an open and transparent government. We have this little thing called a notice requirement for open meetings. It requires 24 hours notice of a meeting, and then it requires 2 hours notice in the event of an emergency. Has anybody here been able to figure out what an emergency is? I've opined on it several times, and I think it just depends. And I don't think that's anywhere in the statute, and you're not going to find it anywhere in an opinion of the Attorney General. And so we've got these time requirements, and sometimes that's why our friends on the commercial side and the business community say nothing moves as slow as the speed of government. That's where that sort of thing comes from, is that as government we have to be very deliberative about what we do and when we do it, because we have these requirements about noticing these meetings in the length of time. So sometimes it's not practically convenient or expedient to provide the appropriate transparency. And then sometimes things just blow up. Things that public officials think are really not a big deal, and so they'll put an item on the agenda and it'll say approval of vouchers. One of those vouchers happens to be a $150,000 legal bill from Von Briesen and Roper, and all of a sudden the public is just outraged that we would pay that much in legal expense to this law firm from Milwaukee, even though it's money incredibly well spent. And so sometimes it is just that, an honest mistake. And so I think when we talk about, at least when I counsel my clients and the people that I interact with on open meetings compliance, assuming that we all agree in this whole concept of a transparent government process, How do we make sure that we're on the same page and have a common understanding of what openness and transparency really means? And the thing that I always refer back to when I'm talking with clients is that declaration of policy that's contained in section 19.81. It's cited in every single court case that you're ever going to read about open meetings. It says that the public's business is the public's business. And so I tell my clients, sometimes they'll ask, do you think that this is really a valid reason that we can go into closed session, or do you think I really need to be more specific on my notice? I always say, look at 19.81. Because the first thing that you're going to hear out of the judge's mouth when the judge looks at you and says, do you believe in your case, they're going to say, here's what the declaration of policy is as it relates to open meetings. And so if you are fully invested in that declaration of policy, you believe in it, can you with a straight face answer the question, should we do this, understanding that that's the policy of our state? So I think that that declaration in 19.81, even though it doesn't have the type of force of law that some of the other statutes have that are very specific, like the exceptions for the open meetings law under 19.85 1C, that declaration of policy is critically important, at least it has been in every case in which I've been involved. So I'm going to tell you, too, about just one of the real-life stories that I've encountered involving the intersection of the open meetings law and then the government's ability to do business. This involved a particular issue in a rural county in Wisconsin where that county had absolutely no zoning code. None. No zoning. It was all just open game in terms of zoning. And so what happened is a large livestock facility wanted to site in that county. Well, you can imagine that with large livestock siting comes a lot of public uproar, upheaval, concern, upset, go down the list. All right? And so the county was forced into considering the adoption of a zoning code. Well, I come from a farming background in my family. You can imagine how the farmers felt when they heard their government was going to start pushing a zoning code on them. And so it was a tremendous issue in this very rural county in Wisconsin. To the board's credit, the county board's credit, when they were going to hold a public hearing on this issue, they said our county boardroom and our facility here isn't big enough to accommodate all the people who want to come and testify and hear what's being said about the adoption of our zoning code. So we are going to go to the local tech college. We're going to rent out their auditorium. We're going to invite everybody over there so that we have enough space to accommodate that. Great idea. I said, that's a wonderful idea. That's absolutely what we should be thinking about if we believe in this whole concept of open government. What was the problem with that? Every single farmer in the county drove their tractor and an implement behind it to that facility and parked there so nobody could actually get into the auditorium. Interesting. Interesting issue. So, when we take a look at some of the challenges under the open meetings law, some of the challenges that local governments and school districts face as they look to comply with the open meetings law, I'll tell you about a couple of areas that I see on a regular basis. The first is with this whole definition of a governmental body under section 19.82. And there is a long laundry list in there of what is a governmental body, but there are a couple of points that I think cause some real heartburn as it relates to that definition. Number one is a governmental or quasi-governmental corporation. What is a quasi-governmental corporation? And I'm sure all of us know exactly what it is after we read the Beaver Dam Area Development Corporation decision, right? And so what is a client's favorite thing to hear when they ask a question like, am I a governmental body? And a lawyer says, well, it depends. And let's go through this 8-factor analysis. And then even after we go through that analysis, you might find 3 or 4 different lawyers who will conduct that analysis in a different way and reach a different result. That's a nightmare for clients. That's a nightmare for compliance. And so one area where, at least from my perspective, I'd like to see improvement is trying to hone in on the definition of what is a quasi-governmental corporation. We had a case that actually went up to the Court of Appeals. It was under the public records law, but it dealt with a very similar issue of what is a quasi-governmental corporation. And we really focused in on this whole concept of that corporation's ability to exercise some sort of governmental authority or function. And so when you look at what the legislature intended under the open meetings law and under the public records law, the public's business is the public's business. Well, if that entity is not doing the public's business, it's not the public's business. And so we focused in on that whole authority thing. That kind of goes a little bit different than where Beaver Dam was going. But I think that if we were to improve upon the law and the definitions that are in there, we would focus in on this whole concept of defining what is the public's business. The other thing that's interesting about Beaver Dam, just as a side note, is that I'm not sure that Beaver Dam comes out the same way today with this Supreme Court as it did back in 2008. And so that adds another level of uncertainty as it relates to the application of that particular decision. The other area where we see a lot of consternation is in the definition when it talks about a formally constituted subunit of any of the foregoing. What is a formally constituted subunit? And you start going down the layers, so to speak, of government. And I have a case currently at the Court of Appeals level, and there is the anarchist firm from Milwaukee, as they were called this morning, on the other side, who's in attendance, so I'm not going to say too much about this. They're on the other side of me here. It's involving a school district. And it's very easy to say the school board, that's a governmental body, all right? That's subject to open meetings. A committee of the board comprised of board members, absolutely, that's a governmental body. A committee that the school board authorizes that includes not only board members but also perhaps a superintendent or designee, that's likely going to be a governmental body as well. School board says to the superintendent, hey, why don't you go ask 4 employees what they think about this and then come back to us with a report. Is that a formally constituted subunit? What if that report comes back to the school board without any sort of initial push from the school board to say, get me this report? But the employees just get together and say, hey, you know what? We think it'd be a good idea if we resurface the football field and use that field turf instead of natural grass. Organically, the employees just got together. They met. They discussed whether they should replace out natural grass with field turf. And then they took that idea and said to the school district clerk, put us on the agenda for the next meeting. They show up at that next meeting and they say to the school board, hey, we got together as a group and we decided that, you know what, we ought to replace out our natural grass with field turf. And the school board says, hey, sure, that's a great idea. Why don't we go ahead and do that? Was that group of employees a formally constituted subunit? And so I bet I could even pull this room and find a divergent answer from all of you. You know, there is room for debate on both sides of that. So I think it would be helpful if we had some clarity in the law before my case is over that tells us what is or is not a formally constituted subunit. Next, we've got this whole definition of what is a meeting. Assuming we know and can define as to whom the law applies or what type of entity the law applies to, what is a meeting? And we've got the Showers test that helps us define what is a meeting. And I always refer to it as the 2 Ps, people and purpose. If you got enough people to conduct governmental business or impact governmental business, and you have a purpose, you know, the reason you're meeting is to discuss governmental business or act on governmental business, you got a meeting. That's the Showers test in a nutshell. But then we get into this whole concept of negative quorums or walking quorums and things like that, and that's where it gets ugly. I heard earlier this morning that one of the holes in our open government law is that caucuses at the legislature are excluded from this whole transparency requirement. I agree. If caucuses were subject to the same transparency requirements, I think that there would be a perfect way to describe the relationship as it relates to open government between state and local government. Local governments are, for the most part, nonpartisan, all right? The boards, the commissions, the committees, the councils, all of them are nonpartisan, all right? But how many of you have ever seen the Dane County Board? How many of you actually think that that board's nonpartisan, all right? And it's that way all around the state. You'll find that there are very partisan factions on these local boards. What don't they have? They don't have the ability to caucus. So they don't get to go behind the closed doors and discuss how they are going to vote in unison on a particular topic. They don't get to horse trade on particular legislative measures. And so the interesting thing to me, and I've never had a good answer for this, I always ask this question. I say, okay, here's what the walking quorum definition is. And this is straight out of Showers, I believe. A walking quorum is a series of gatherings among separate groups of members of a governmental body, each less than quorum size, who agree tacitly or explicitly to act uniformly in sufficient number to reach a quorum. That's the definition of a walking quorum. Now, what's the difference between the definition of walking quorum and the definition of politics? Tell me what the difference is. We all know what happens. We all know what happens. And so when I get into these discussions, particularly with local elected officials, I can sit there with a straight face and say, you only talk about the public's business within these four walls. That's the only time you can talk about the public's business. Now, do you think I really believe that that's what they're going to do? Absolutely not. Absolutely not. So the only thing we can do as advisors to these municipal, county, school district groups is to say, look, if you're going to talk about stuff, don't have a quorum, don't have a walking quorum, don't poll, because I've even have people ask me, hey, if I don't take a poll but I have my neighbor take the poll, is that okay? No, it's not okay. You're doing the same thing through surrogate that you can't do on your own. And so realistically, you've got to avoid these types of issues to avoid the appearance of impropriety. Because I always say, too, that the newspapers, the press, the radio stations, they're watching. And so if you have a big, big issue that's going to be brought to the board floor, and everybody shows up, the chair reads the resolution, and the chair says, we're now open for debate, and you hear crickets, what do you think the press is going to think? Oh, this is a predetermined outcome. And that's exactly, by the way, what happened in Showers. It was a predetermined outcome, and they got to that meeting, took a vote, and that was the indicia of a walking quorum had occurred. So oftentimes there isn't the smoking gun. There isn't the email that you're going to find about these things. There isn't a recorded conversation. What it is the absence of real honest debate on a matter of public concern. And so be very wary of that as a local official, that there are people who are going to watch that, and that is, again, indicia of a walking quorum. The only thing I want to point out, too, as it relates to this whole concept of what is a meeting of the members, we talked about people and we talked about purpose, is that I had another case against the anarchist from Milwaukee that actually involved Milwaukee County. And this case is done and over with. You guys didn't appeal that, right? We're good. All right, good. This case was very interesting in that the allegation is that a quorum of the county board met in Madison to lobby against what eventually became known as Act 14, which limited the size and power of the Milwaukee County Board. And the only reason that they were in Madison was to testify in opposition to this particular bill. And the question is the fact that there is a quorum of the county board in Madison to testify in opposition to this bill, is that a meeting? And I will tell you that we were successful in getting summary judgment and saying it's not a meeting, based solely on the fact that there is nothing that the Milwaukee County Board can do in relation to that legislation, because they are subject to whatever the state says they are subject to. And so we successfully argued that, look, I don't care if the Milwaukee County Board goes to the League of Nations to lobby against human rights issues over in Libya. If they want to do that, they can do that as a group. It's not a meeting, because they have nothing to do officially in their governmental function with the business of the United Nations or the business of the state legislature. Now, I will be honest, the case is done. It hasn't been appealed. I don't know if we're entirely 100% right, because there is no published case out there. There is no Attorney General guidance telling us that that is the bright line rule that has been established, okay? So what is a governmental purpose? It's all well and fine that we have the Showers test, and we know that you have to have people and purpose, but what is a governmental purpose? I think that would be helpful. And I think that also folds into that whole concept of the definition under Beaver Dam as to what constitutes a governmental body. So with that, I will end the comments at this point, turn it over to Chris, I believe, and he can go, and I think we're going to take some questions at the end. Thank you.
So a lot of what we're talking about here today is black and white and lots of gray. However, as I've sat here today and have seen most of you stick around today, there is one undisputable fact, and this comes straight from the program. Note, a request for CLE credits has been submitted to the Board of Bar Examiners. So I know why all the attorneys are sticking around today to the very end of this. This is actually, the whole day has been a great topic, because this topic is so vitally important to informed citizenry. And I would agree with Andy and agree with the public officials here today that in my experience, problems with open meetings they've been exceptions rather than rules, that most governmental bodies do want to comply and do their best to comply. The problem is often rooted in ignorance or a misunderstanding, particularly in Wisconsin, where we have so many layers of government, where you have a lot of turnover sometimes, and you don't have a really good conduit for training for a lot of these folks. Now, I will give former Attorney General Van Hollen a lot of credit for setting up open records and open meetings around the state to invite public officials. I would certainly hope that there's some kind of effort for that to continue, because that is vital in order to comply with the laws, to understand the law. But when you have these small towns, sometimes in Wisconsin, and they don't have the luxury necessary of having fine attorneys to advise them, they are sometimes doing what they think is best, and what they think is best is not always in compliance with the law. And so there are some common problems that I have seen over the years when it comes to adequate public meeting notices and closed session notices. Notices need to contain time, date, place, and subject matter. They cannot be generic notices. It has to be information that must be sufficient to alert the public to the importance of the meeting so they can make an informed decision whether to attend. It can't be a notice, board's going to meet. And honestly, I've seen some kind of agenda notices over the years that have been that vague. And it can't be just the same meeting notice month after month. It has to be very specific to what you are addressing. So it has to stay on topic, and that has to be essential. Because if you're going to inform people about what their local government is going to be doing, you have to have that information. When it pertains to closed sessions, the most common thing that I've seen over the years is inadequate notices. It must contain the subject matter of the closed session and the specific statutory exemption. No generic closed meeting sessions. Again, I've seen a lot of generic closed meeting sessions where they just kind of vaguely describe one of the exemptions and say that's why we're going to go into it, without being specific about what it is under that statute that they're going to discuss to make it a legitimate closed session. The other problem with closed sessions, and bill leaders alluded to it earlier, is in closed session is you must stay on the business specified in the announcement. But unless there's someone in the room keeping tabs, how do we know? And again, I'm not suggesting that this is a deliberate attempt by public officials to, well, we're going to say this, but we're really going to do this. It's unless somebody is specifically trained in that closed session to say, no, folks, we can't talk about this topic because our reason for going into closed session is on this very specific and narrow topic. It doesn't give us a license to talk about whatever it is that we want to talk about because the public isn't here anymore. We had, in La Crosse, we had our local technical college had gotten into routine of going into closed session at every board meeting to talk about contract matters, and it became basically a way for the college president to talk about to the board about some confidential things. Even if they didn't intend it, it became part of their fixture on their meeting agenda. And we approached them, and they admitted, well, actually, we shouldn't be doing that. And to their credit, they said, no, that doesn't comply. But that's sometimes the slippery slope, and it can easily happen if someone's not paying attention to those meeting notices, and every once in a while challenge them to say, is this really what you're doing? Are you keeping to that? And so I would certainly be in favor of the proposal to tape the closed sessions, because I think that's again, would be a precaution. It'd be a simple measure to make sure that if there are ever any questions, that you can review that the closed sessions are being held legally. And before I turn it over to my next colleague here, I think that really one important point to talk about here, when there are multiple reasons to go into closed sessions, but let me just quote from the packet that's with you today. Wisconsin Statute 1985 sub 1 contains 11 exemptions to the open session requirement, which permit but do not require a governmental body to convene in closed session. I want to say, do not require. Sometimes, and no offense to my legal friends here, I think sometimes governmental bodies listen too much to attorneys and they become a little too scared about, are we doing this right, are we doing this wrong? They don't have to go into closed session. There's nothing that says you must go into closed session. They do it for a lot of good reasons, but I just want to point that out. The statute doesn't say you're going to get into trouble if you don't go into closed session. You may go into closed session, and I think that's where we have kind of the obligation to make sure that the notices are correct and that they're staying on topic. It continues on to say that because the law is designed to provide the public with the most complete information possible regarding the affairs of government, exemptions should be strictly construed. The policy of the Open Meetings Law dictates that the exemptions be invoked sparingly and only where necessary to protect the public interest. If there is any doubt as to whether closure is permitted under a given exemption, the governmental body should hold the meeting in open session. So even the fallback is, if you're not sure, hold it in open session. And I think that just by following some of those guidelines, making sure that public officials are informed about what the rules are, and by following these things, that a lot of these things can certainly be eliminated or avoided. Thank you.
Good afternoon. Again, extend my thanks for the Attorney General for holding this. I'm going to echo a few of the comments here of my colleagues on the panel. As Dave mentioned, I'm the Chief Legal Counsel at the Public Service Commission. Many of you may not know what the Public Service Commission is. We are the state agency that is charged with regulating all of the public utilities in the state. Clearly, we are a statutorily created entity under 1579, so we are a commission. We are quite clearly within the Open Meetings Law. We are a governmental body. It's not one of those gray areas that there are in that definition of governmental body. We're certainly squarely within the Open Meetings Law. We have the unique challenge in that we have 3 commissioners. And the open meeting law says if more than 1/2 of your members convene, it is presumed to be a meeting. I've got 3. So it presents some challenges that we deal with on a daily basis as to how do we get the business of the state done in regulating the public utilities and doing it consistent in an efficient manner, consistent with the open meetings law. I'm going to conclude my talk with kind of on the theme of today on technology and the open meetings law, and highlight, just by way of example, some of the things that the Public Service Commission has done in really trying to use technology to the fullest to really satisfy the fundamental tenets of the open meetings law, which is having sort of an informed public that knows what we're doing and why we're doing it. We're very fortunate at the Public Service Commission to have an unbelievable IT staff that makes many of the things we do possible that I'm sure other agencies or local units of government may not have. We also have leadership at the commission, and currently in the form of Chairperson Nowak, who is also very committed to looking for ways to make sure that we're going really above and beyond what the open meetings law requires in terms of making our meetings accessible to the public. So I'll conclude with touching on that and recommending for consideration for subsequent discussion, really perhaps some changes that in the open meetings law that might be necessary to accommodate the new technology. Touching on some of the things that Andy said in terms of the definition of governmental body, you know, I share his concerns that really it's that quasi-governmental body, quasi-governmental corporation that really, I think, sometimes causes me to scratch my head on a daily basis when staff will come to me and say, well, Cindy, we're getting together this group of stakeholders that have environmental reps and consumer advocates and utilities, and do we have to notice that up as an open meeting? When are advisory groups like that, stakeholder groups, when do you cross that line? Clearly the commission has Certain statutorily created councils, like the Wind Siting Council, those quite clearly fall within the definition of governmental body and subject to the open meeting law. But where do we go in terms of these quasi-entities, the stakeholder groups? When I'm asked that, sort of the questions that I ask myself, and perhaps it'll help you is when you're posed with those questions, is I go back to, all right, what's the genesis of this conglomeration of people? Was it something that the commission ordered and said, you shall convene a group of stakeholders to discuss this issue and report back to the commission? So what's the originating source? Is it a statute? Again, that's pretty clear then. What is the constitution of this group? Touching on the showers test, and is this a definable number such that you know if you have a majority present or not? And then thirdly, sort of what authority does this group have? Can it make recommendations that it will take to the commission for decision? But I agree, some clarification in that area in terms of what are the indicia to help us navigate that question would be helpful. As I mentioned, I have 3 commissioners, so the issue of when is there a meeting and convening of members is something that the first day a commissioner walks in, I basically say, it's like, well, welcome to the commission. You really can't talk to your fellow commissioners unless we're in an open meeting. And they look at me and they're like, well, what do you mean? I said, well, you know, we have to conduct our business in an open meeting because there are only 3 of you, and if one of you talks to the other, I've got a majority. So I'm fine if you want to talk about your family, the weather, but we're not going to talk about any business. And that takes some adjustment, but I think I sufficiently scare the crap out of them enough that they go, okay, we don't want to get Cindy mad, so we're just going to talk about the weather. We also have set up a lot of different protocols in place to ensure that we are complying with that. The other challenge that sometimes the commissioners have is a lot of the matters that the Public Service Commission deal with are highly technical. They are multidisciplinary. They involve very esoteric accounting questions, engineering, finance questions. And they're complicated issues, and there's multiple issues that they'll have to address in a given case. And I think it's a bit unnerving, at least at first, for commissioners to come and not know when they enter a room where their colleagues are. And that takes some getting used to. The way we deal with that to make sure that the commissioners are each getting the information that they need, they have full access to staff. We have to watch very carefully. I think Andy touched on the definition of walking quorums. So not only can I not have sort of the 2 commissioners talking with one another, I can't have daisy chaining of information happening to sort of circumvent that. So, you know, a commissioner can't go to staff and say, you know, I'm really thinking about approving this route. Why don't you see what my colleague wants to do on that? We don't do that. Staff are specifically instructed that, you know, for those of us who are lawyers, I think when you think of sort of your attorney-client privilege, I view myself, at least in we're preparing for decisions, that I have 3 separate clients, and what I talk to with that individual stays with that individual. And our staff is trained to do that as well. Unless they perhaps stray, when commissioners are preparing for an open meeting to ensure that we don't have walking quorums, there is usually an attorney present, whether it's myself or one of the staff attorneys, that are in each of the briefings to make sure that we're not daisy chaining information and having a walking quorum issue. Our general rule of thumb when we get to, all right, I'm convening a meeting, is it a meeting that I need to notice? My general rule of thumb is if I am going to have 2 commissioners present, even if we aren't going to take some official action, our habit is usually to notice that. So for example, we do a fair amount of contested cases that really are quasi-judicial proceedings before an administrative law judge at the commission. They have multiple different stakeholders with differing positions, and we have hearings, both technical hearings and public hearings. A lot of times the commissioners will want to attend those and be able to ask questions. And so if I know more than one commissioner is attending, we err on the side of providing notice that we're having this hearing and more than one commissioner may be present at any one given time, but no action will be taken at this. The other sort of proactive measures that we do is that we try to minimize, and this starts to get into the issue of technology. We try to minimize the emails that either myself or the secretary of the commission sends out. Obviously making sure they have information necessary for their decisions and for discussion at the open meetings. The law clearly provides we can push out one-way information. But in the advent of email and the dreaded reply to all, that's something that we do with caution. And again, there's nothing nefarious. We've all done it. How many here have not accidentally hit a reply to all? And sometimes that happens. So we really try to minimize in our use of what we're doing. I also am pretty explicit, and I'm sure they're sick of reading it, but at the end of any email when I'm pushing information one way out to the commissioners, I say in big letters, consistent with the open meetings law, this is a one-way communication. Do not reply to this message. And by and large, they do a really good job of not doing that. We have also instituted, and there was some discussion earlier about tablets and electronic meeting minutes or meeting materials. We try, to the extent practicable, to be relatively paperless at the commission. So when I first got to the commission each week for an open meeting, they used to get a big binder like that that had all the materials in it, hard copy paper. We've moved away from that, and we have what's called, we call it the e-agenda, and it's an electronic agenda, and it provides links to the meeting materials. That is a good way where it allows us to push out information saying, new information for agenda item 15 has been added. Please resync your tablet. And they get the new information. So again, it avoids having substantive discussions or that could result in an open meeting. In terms of one other area, which would be helpful for some clarifications. As I said, there's a presumption because I have 3 commissioners that if 2 meet, I have a meeting. However, the law specifically provides that chance social gatherings and conferences are not meetings. But then the case law and the guidance documents and Attorney General opinions are rather scarce as to what is a conference. A couple of cases tell me what it isn't, but none that really tell me what it is. So what I tend to do, and again, because we are in such a highly technical area, there's a lot of education that goes on, and it's obviously a very developing area. So there are lots of seminars, webinars that are offered, and more than one commissioner may want to attend those. So when we have those types of activities, I ask myself a series of questions as to whether or not this constitutes a conference. And this is where I think the law would be helpful to maybe spell out perhaps some of these criteria or indicia of when you fall within that conference exception or not. I ask, do the commissioners have power to set the agenda? Are they going to be passive participants, or are they going to be taking some sort of active role? Will a commission decision be made? Is the conference run by a third party that controls the agenda and sets the invite list? And is there a payment of fees? And so I sort of look to those criteria for me to ascertain, okay, well, here's something it's a webinar. We need to pay for each individual to participate in this webinar. We're not making a decision about anything. Perhaps it's providing background information on rate-making principles or something like that. Because it's not our agenda, they pay a fee. I think that falls squarely within the conference exception and not something that I would notice. On the flip side, we just a couple of weeks ago had a group come in that's been doing research on some rate design issues, and we had all commissioners present, and we publicly noticed that such and such will be giving a presentation on some grid research that they're doing, and we invited the public to attend. So again, we do generally err on the side of providing notice, and making sure that we're in compliance with the law. Let me talk now a little bit more in the last few minutes that I have about technology and some of the things we've done and where I think there might need to be perhaps some changes to the open meetings law to accommodate technology. The first is on notice. I think both Andy and Chris touched on some components that the law requires in notice. It needs to be 24 hours in advance unless there is an emergency, and it needs to contain the particularities enough such that a reasonable person could ascertain what you're doing. So first, in terms of posting of the notice, 24 hours in advance. The statute is not clear as to what constitutes that, but the general guidance that's still in there is that notice to the public is generally by, and I'm sure many people who post, yes, stick it on a public place in your building. At the Public Service Commission, we have it on the first floor. We physically post our agenda the day ahead. We also email it down to the Capitol, and it's posted in the Rotunda. We email it to media that have requested, but we also post it on our website. And I dare to say that 99% of the people who are interested in the business that we do aren't coming to the Public Service Commission or looking in the paper to see if there's a publication of a meeting or going to the Rotunda. They're going to our website at psc.wi.gov. And you'll see from the slide there we have event calendar. You click on event calendar and you get the calendar. And we have a little color coded, and this is all of our public notices that we do for meetings that we have. That will show when we have an open meeting. And if you click on those things that say open meeting, you will get, for a given open meeting, you will get a copy of the agenda that is physically posted in our building and has been emailed to those who have requested. As to the specificity of the notice, our practices, the Commission has an electronic regulatory filing system, much like a court case system, where everything that comes before us is assigned a number so that we can keep track of it. And we have very detailed descriptions as to, okay, what it is that that number, what's the utility asking us to do there. And you can see sort of the specificity that we have in our notices. We go one step further. Again, I think we're give very good detail in terms of what the action item is and what it's about. But we also now go one step further. And, oops, I went the wrong way, I think. Oop, not sure where that went. We have, you'll see on that slide, a public e-agenda. So once the agenda is set, and it's usually about 2 hours before the start of our open meeting, I heard that there were concerns of people that had tablets that they don't have the meeting materials. Well, that's not how it is at the Public Service Commission. If you go to our website or you're in our building, we have Wi-Fi access, and you'll see now on event calendar, e-agenda. You click on that e-agenda, and you physically get the agenda, and you have links to all of the documents that the Commission, the public documents the Commission is reviewing in order to make its decision. So you'll see the minutes, the draft minutes that they're approving. You'll see the notice that the Commission is either going to approve or deny. So not only do we describe in particularity the item, we actually give you the underlying documents so that you can see what that action item really is. So with regard to notice, I think that a consideration could be given to give a little bit more flexibility in terms of what does constitute sufficient notice and whether electronic posting on a website, which again I think is where the vast majority of people get that information. We also tweet when we're having an open meeting as well. That those sources perhaps need to be reflected. A couple of years ago we went through the statutes that regulate public utilities and sort of did a technology update to say, okay, utilities don't need to post at pay stations, whatever the heck those were. We allow them to provide it in terms of an electronic copy or a manner that's reasonably accessible to the public. So some sort of update to reflect how we give notice and posting I think would be helpful. The law also requires that your meetings are accessible to the public and accessible to any of those that may have disabilities. What we have done at the commission, yes, we have a large meeting room, a couple of them, which we still have. And I might note, even though we do post on the internet our meeting notices, we still do all the paper stuff too, until the law gets clarified. We also now have broadcast of all of our open meetings. You go to our website again, and you go to PSC Live Broadcast, you click on that, and you'll get the live broadcast for that day. That happened the day I did this slide. We weren't having an open meeting. If you were to go there today, you'd see up on the PSC where it says, it will say open meeting, and then it'll have those two little blue boxes there, or actually probably one blue box. We only do audio for our open meetings. You'll see that the day that I did this, we had contested case hearing that you could listen to if you're hard up for entertainment. And this also, we found, is people really like having access to this. The media don't have to schlep to Whitney Way to see our meetings. They can listen online. They get the meeting materials online. And the chairperson has tasked our IT folks with trying to make our open meetings also real time. Sometimes there's handouts in the middle of meetings, because again, the commissioners can't communicate with one another. They may have a set of conditions, written conditions they want to see attached to a certain application. Or we do a lot with math, which I went to law school, so I didn't have to do math, but unfortunately we do a lot with numbers here in terms of like rate design. How are we going to allocate if there's a rate increase between the different rate classes? And commissioners are far more into math than I am, and they have all these formulas. And so that gets handed out at a meeting, because they can't hand it out before, because that would disclose what one commissioner may be at, so like they just spring it on them at the meeting. So Chairperson Noack has said, well, it'd be really nice when people are listening and we have these handouts that they'd be able to see that. And so we have a new feature now where if there's a handout during a meeting, we also post that handout in real time as well. The hearing broadcast also is nice for those that have disabilities. We are required to accommodate that, whether that be having a signer physically at our meeting. What we found by broadcasting our meetings on the internet, there's our services that will listen to our broadcasts and then can Skype and sign to the individual who has requested the accommodation. We certainly pay for that, the signing service, but it's a lot easier because they already have the live audio feed. With the accessibility, the one area that I think causes some consternation just with my litigation background is the interrelationship between sort of the open meetings law and Wisconsin Chapter 227, which is the Administrative Procedures Act, and sort of the interaction between, and we've touched on it a few times today, between the open meetings and the public records law. And those of you, how many here are with state agencies? Okay. So when your agency may make a decision in a contested case, it is based upon an administrative record, may have hearing testimony and the like. And if that decision is challenged and goes to court, the evidence that the court must review is the record. The problem is, with all of the openness that we have with open meeting, I get people who then try to stick into the record or say it's part of the record transcripts from open meetings, videos from open meetings. Remember, the law requires that if someone wants to record or tape, as long as it is not disruptive, that you are to accommodate that. So I get all this other extra evidence that's outside the administrative record. What do I do with that? So that's one challenge that the transparency presents when we get into court, who's already scratching their head because they're having to review one of our decisions, which are pretty complicated to begin with, and now there's this other stuff. The other point that I'll conclude on is sort of, we've touched on it a little bit in our discussions, is the interaction between the open meetings law and the public records law. There's been talk that we should record our closed sessions. I'm not sure I'm so wild about that. How would that then be treated in the public records law? Again, so if that's, you need to make sure that if we're making changes to open meetings law, that there's a change perhaps in the public records law to make sure that those two things work in sync. The other interesting issue that fortunately it hasn't come up, but these are the kinds of things that keep me up at night, is if I get a public records request for a commissioner's emails, maybe with his or her executive assistant, who's really their right-hand person in making the decisions. And this is in advance of an open meeting. Can I turn over that information from one commissioner in the public records? That circumvents the open meeting. So if someone requests a commissioner is thinking on that, by releasing that record and making that public, have I then created sort of this walking quorum type issue where another commissioner knows and we have that? So those are some of the things that I think we need to be cognizant of, that the two laws really do work a bit hand in glove, and if we are going to make changes to one, we should contemplate making sure how they impact the other.
I'd like to thank all our panelists again today, and after I pose a few questions, I'll open it up to the audience, and then we'll conclude the summit by having the Attorney General come back up and make a few closing remarks. Cindy, in particular, thank you for demonstrating what the PSC is doing by way of technology. I think it's probably fair to say that you're on the cutting edge of Wisconsin government in that regard, at least from what I have seen, and I'm sure it's appreciated by your constituents. I'd like to ask or pose a general question to the other two panelists, having seen some of the technology changes, technology-driven changes that Cindy has described at the PSC. Do you have any thoughts in your sphere of activity and experience where those issues or those developments would have an impact, or other technology that you'd like to see in the situations you confront?
Yeah, and maybe I can, is this on? Maybe I can start with comments about, from what use of technology varies greatly around the state. I don't think that's a surprise to anybody. And so, for example, I know Milwaukee County has real-time recording video, audio of a lot of their meetings. You're not going to find that in a lot of different areas throughout the state. So in terms of the impact that technology has, I think that it's a commitment both in terms of the effort to create the technology that allows the public to attend a meeting. And remember, the public has a right to attend a meeting. The public doesn't have a right to speak at the meeting. They have a right to attend. And so it takes a commitment from the local agency to say, we are going to commit to the technology to allow the public to attend, but then it also takes a monetary commitment. And fortunately or unfortunately, oftentimes technological advances like that fall below things like fire protection, police protection, human services, highway maintenance, things like that. And so I think it's a function of both commitment to the use of technology and then also commitment from a resources standpoint.
I think it's also wonderful when people can get more access through the use of technology, such as being able to listen in on hearings and to see documentation. I mean, it just makes it much easier. One thing that Cynthia mentioned that made me squirm a little bit was a reference to, well, we can just post those notices up on our website. And the problem with that is then who polices the agency, and we're to trust that the agency is then doing the posting, and having that third-party intermediary just to make sure that we're complying with all of the public's needs is still, in my opinion, the best method for making sure that the public is informed.
In the area of potential statutory changes, obviously we've heard a number of suggestions all during the day. In regard to open meetings, I think some of the topics, for example, texting during a meeting among members of the entity, to me seem to raise maybe more public records issues than open meetings issues. But do any of you have any thoughts about what might be appropriate in terms of statutory changes specifically directed at open meetings issues? I think one thing that was mentioned was the difficulty in terms of quasi-entities and advisory boards, stakeholder meetings. Is there any realistic possibility of coming up with a statutory definition that would remove some of the ambiguity that we now have?
I think there definitely is. I think that the more that we can provide definition to this concept of what's a governmental body, I think that's better. I think the more we can provide definition to this concept of what is a meeting, that's better. And I think that we could also use some help in folding technology into this. So for example, if you've got an email that relates to governmental business, that email is going to be considered a public record, obviously, but does it also constitute a meeting? I think it would be helpful if we had some definitional guidance as to those electronic communications and what is a meeting. The other thing, let me just mention too, as long as we're on this technology concept, the struggle that I find too is that oftentimes if you have texting that happens during a noticed meeting, that texting could be the meeting within a meeting, and that in and of itself should have been noticed. And so the texting during the meeting is a violation of the open meetings law. And then oftentimes what happens when you go to a carrier and say, give me all of X and X phone numbers, text messages? Well, we don't maintain that. So would you go to the public official and say, why don't you show me all of your text messages? Well, I deleted those 3 weeks ago. And so you oftentimes don't even have the record of the technology that was utilized that created the violation of the meeting within a validly noticed meeting. And that's like a Dr. Seuss novel, so I'm going to stop.
Or you can do a Tom Brady and just destroy the phone.
You jumped my line with that one.
Yeah, in terms of changes, I hesitate, having specificity of saying this type of entity, because then you're going to leave some off. What I tend to find more helpful is, the way I think is, these are the types of criteria, or these are indicia of, as opposed to trying to list off every type of things. If it has this, this, and this, or any of the above, that gives some flexibility without trying to list. We touched on a little bit closed session, and I get that, we use those sparingly, which I think we're true to that at the Public Service Commission. There's one in particular that is just weird, and for those of you who are with state agencies that have open meetings and also do contested cases, there's a exemption from the open meeting which would allow you to go in closed session under 19.851A that says you can go into closed session when you are, quote, deliberating concerning a case which was the subject of any judicial or quasi-judicial trial or hearing before that governmental body. I read that, and again, this is where there is not a lot of law. What's a case? There's a little bit. I would read that, arguably, that we have quasi-judicial proceedings before an administrative law judge. We have competing interest. It's not just, granting a permit or not, which I think is one of the few cases on that exemption. I read that we could certainly arguably use that to go into closed session to talk about contested cases, which seems counterintuitive to me because it's those contested cases that are subject to the quasi-judicial that are the ones the public is really most interested in learning. So I think taking a look at some of the closed session exemptions, that one in particular is a little odd. The other one, which doesn't always fit because I think it is a bit too narrow for today's day and age, is the competitive bargaining exemption that's there, and it allows, but it only if it is required. There are numerous instances, at least in our, what we do as an agency, where we're not necessarily dealing with a contract, and we have on one occasion done that, but we do a lot where the position of Wisconsin, as it relates to regional energy markets, is and may be different, and there are competitive bargaining positions when we go to some of the more regional meetings. That's not something that falls within, as currently interpreted and drafted, the competitive bargaining. Now, fortunately, a lot of those are also in contested case or litigation proceedings, so I think it falls within another exemption for conferring with counsel. But I think a closer look at some of the closed session exemptions would be helpful.
Thank you. I'd like to open it up to the audience now and see if we have any questions. Yes, in the back. Yes. Oh, I'm sorry. We'll get you a microphone and carry you around.
I haven't heard any mention yet today about, in terms of open meetings law, whether there's a complaint that the open meetings law has been violated. The experience that I have is with a couple of different counties. First of all, almost every complaint goes to a district attorney who refuses to investigate it and almost always passes it off to another district attorney in another county who does not answer to the voters of the county where the complaint was lodged. And so he doesn't really care in most cases. We recently had one in Calumet County of an allegation by a private party about an open meetings law violation. It was sent to the district attorney in Outagamie County, who did a very complete and quick job of addressing the issues raised in the complaint. But about 4 years ago in Brown County, the County Taxpayers Association filed a very serious complaint that the county administration had formed a series of committees to develop a new $18 million public safety radio and data communications system. The committees that were all established, there was no record of them, of who was on them. No minutes were taken at any of their meetings, and none of their meetings were posted. The County Taxpayers Association got significant information about that, considered it a violation, filed a complaint with the district attorney at the time, currently Judge John Zakowski. Zakowski passed it off to the district attorney in Sheboygan County, who sat on it for over a year, almost a year and a half, and then concluded, well, I don't think there were any violations, and besides, the contract's already been awarded to Motorola anyway. Where is the accountability on the part of the public officials in the district attorney's office, or in the attorney general's office for that matter, that complaints about open meetings law violations are taken seriously, are investigated promptly, and are resolved correctly? Anybody care to make a comment on that? I guess it's more of a statement here, but I think it's a serious problem. We can talk all we want to about how wonderful the law is and how maybe it needs a tweak here and there. If it's not enforced, it doesn't mean a damn thing.
I can give you the local government perspective here, and that is, as soon as I have a client who finds out about a complaint that's filed with the district attorney or the threat of a complaint that's filed with the district attorney, I always encourage the agency to start talking with the district attorney or the complainant about potential resolution. But that brings up a great point. I mean, you're absolutely right, and there's nothing, as representing local governments, we don't control prosecution, we control defense, and so we react when a case is filed. But I'll tell you, there are some logical concerns at play here too, and that is, from our side, there's a fee-shifting mechanism in the statute, and so there's a tremendous disincentive to prolong litigation, because then the other side's tab, if we lose, we have to pay for the other side's lawyer, and that's a tremendous disincentive for us to continue litigation. But one of the things that frustrates us is that we may have an issue, and you may know this from the county perspective, county boards have several committees. Those committees meet and form recommendations that they bring as resolutions to the county board, and the county board independently acts to approve or disapprove of that resolution. And so in reality, all the committee is doing is recommending a course of action. Well, what happens if the committee violates the open meetings law, and as a result, it has an illegal closed session where it adopts a recommended course of action for the county board, forwards that recommendation to the county board has a legitimate and valid open meeting, debates and adopts that resolution, but then down the line, somebody says, wait a minute, that committee that made the recommendation violated the open meetings law. Therefore, according to statute, what that committee did is void. The recommendation goes away. Well, what happens to the underlying county board action, which nobody claims was a violation of the law, but all of a sudden that action's clouded because we had a recommendation that was a violation of the open meetings law? I'd like to personally see some clarification on the remedy side as well as to what happens to official actions. Because the other thing that we have is that my advice consistently to local agencies is, if you want to remedy this issue, then properly notice and hold a valid open meeting and take the action to ratify what you did that is alleged to have been done illegally in a closed meeting or a not properly noticed meeting, and that's the remedy. So I would like to see some clarification personally on that remedy phase as well, but I can't speak specifically toward the time of prosecution or the ability of certain prosecutors to handle these things. I know they're short-staffed, I know that.
I guess something I would add to that is that, and I think we saw that on the July 4th weekend, that public pressure still means a lot in this state. And if you had a case where a DA was really sitting on it and, as you said, not really caring about it, I think informing the public and letting them know about what's going on still carries some weight. Don't know if that was the case here, but I mean, I still think that there are some things that we can do. And acknowledging too that, district attorneys have a lot on their plate, but also having conversations about, hey, when is that going to get addressed? But the court of public opinion is still important in Wisconsin.
As the lone representative up here with this panel of the Department of Justice, I can just tell you that clearly Chapter 19 has, in the enforcement provisions, it has presented some challenges as to being the most efficient way to achieve the goals of our public records and open meetings laws. Having said that, the Attorney General is committed to fulfilling all of our department's responsibilities under the statute, and also looking for new ways to make that process more efficient.
I have a question or a comment regarding closed sessions and a governmental body that appears to consistently have a pattern of having closed session meetings when the majority of the electorate is working, or a time of the day when they're not available to go. Now, I understand that people work different shifts, but when you have, I come from the small town of Palmyra, which is 1,200 residents, and we have I'm just a town resident, not in the governmental body, but we have our town meetings the second Monday evening of the month, and there appears to be a pattern, because I'm keeping track, and lately it's like 75% of the closed session meetings are now happening 10 o'clock during the week, 1 o'clock during the week, where a lot of the electorate that comes to the regular meetings are unavailable. And I'd like to hear some comments about that, or possible clarification with the laws regarding closed sessions and the special meetings.
Any experience in that regard, Andy?
We have that debate consistently with school boards and counties, and I mean, there are some counties that meet at 9 in the morning and other counties where their boards meet at 6 o'clock at night, and I've heard both sides of it. 9 o'clock in the morning, that's when we're available to do business. 6 o'clock at night, that's when the public is most likely to attend. And so I think there's nothing in the law that says that you have to meet at a certain time on a certain date. That being said, I mean, there's nothing in the law that says you can't meet at 2 a.m., but I would have a real concern that, is that reasonably open to the public? Is the public going to really attend a meeting at 2 o'clock in the morning? So it depends on the circumstances. But I don't know how you clarify the law unless the law were to say that you are required as a public agency to meet at 5 p.m. or later. That's the only clarification I can think of, but I think that would pose some logistical problems, because it does take up staff time as well. And you'll have other counties say, look, we don't want to keep 15 staff members over past 5 o'clock. We generate overtime and create a commitment on that financial end. So we'd rather have our meetings during the day when staff is there to inform us, and hopefully the public can attend. But I hear your sentiment, and I know that debate occurs throughout the state.
And here's where, again, where technology, I think, can help For example, we have our meetings during the day because that's when our staff works, but with our broadcast, it remains available through that entire day. So if you're not able to watch live during the day at a 10:30 a.m. meeting because you're at work, you can tune in anytime that day, whether it's 7, 8 o'clock at night, and listen to the rebroadcast. Again, that's not in real time, but that's something where I think you can fulfill the intent of the open meetings law through the use of technology.
Is your concern that the sessions are not, that they're not doing them properly, the closed sessions?
Yes, that's part of my concern. I currently have an open meetings violation complaint that's in process right now. Not on that particular subject, on another one, but there are issues going on.
Regardless of what time they meet in closed session, they still have to convene an open session according to the statute. So there are other ways where you can make sure that they're in compliance with the records.
But one question I have then, if they don't do any motions or decisions, then there are no minutes. So therefore, we get nothing other than there was a closed session meeting.
That's so.
Yes.
As long as there's a proper motion to go into closed session, that's unfortunately the way it works. Any other questions?
What you just said.
Yes.
One of the things that I'd like to address is what you just said. Occasionally, what they're doing also is they're having a meeting to confer regarding a specific issue. Let's say it's annexation. And they're meeting with their attorney, this is a town now, meeting with their attorney, but the meeting is being held at a different city where the attorney resides and has his business, not in our district at all. So they're going somewhere else where they have to go into open session before they can go into closed session, and then go back into open session to close it. That's not convenient to the local taxpayers. Is that kosher?
I'm not aware of guidance on location of meeting. I mean, I have advised certain governmental bodies who are traveling out of their county or jurisdiction for whatever reason that if you notice the meeting and tell the public where you're going to be, even if it's outside the county or jurisdiction, that's still a valid meeting. I mean, the question I would have is that if you look at the purpose of the open meetings law, it's to allow the public reasonable access to a meeting. So I don't know that there's any guidance that's out there about location of the meetings, but I would question as to whether a consistent pattern of meeting outside the area that is served by that local agency would still be a valid open meeting.
Well, at this point, I'd like, again, to thank our panel for presenting here today, and also to... Oh, we did?
Yeah, there's one more question here.
Oh, I didn't see that.
I've got a question about public comments. I understand from the open meetings statutes and the Attorney General's manual that municipalities are not required to have a public comment period. But once they do have a public comment period and they put it on the agenda and they allow you to speak, the 3 minutes, that's typically what they give you, do they have the right to regulate the content of your communications? So it says on the agenda of the municipality I'm talking about, it says public comments is a one-way conversation. They are not going to take any actions on it. I understand that because the item's not on the agenda. But we have a village president that is notorious that if he disagrees with your opinion or what you're talking about, he'll interrupt you and tell you you can't talk about that. What remedy do you have? Once they open up the public forum, can they regulate your content? Can they regulate your opinions, your analogies, your comparisons, your contrasts? Because this is what this individual is doing to people he disagrees with.
I can just tell you from my perspective, you're dealing with a whole host of different issues unrelated to open meetings. Now you're dealing with First Amendment constitutional issues.
I believe, right.
You're also dealing with issues about the right of that body to control the conduct of its meeting and whether if it's up to the chair as to whether a particular statement or activity is going to create a disturbance. They have a right to have a safe and secure environment for that meeting. But in terms of your question, does he have the right to regulate? That's a First Amendment issue, and that's way too involved to get into in this discussion. I don't know if anybody else has insight.
No, I would defer in the same way. It does raise other issues, and you would really have to go into the specifics of all the circumstances there.
But there would be nothing in the open meetings law that would touch upon that. No.
There's no specific guidance.
Yeah, I mean, the open meetings law, says that it's there, that it's at their option if they want to have that. The open meetings law doesn't require them to have that.
Well, I think that should be one of the changes to the open meetings law, is to require a public comment period at all municipal meetings. I think that would be a valid change. I mean, they could regulate the timing of, like the amount of minutes you speak, but I think there should be a requirement, that to allow public comments at all municipal meetings. That should be a change.
Thank you. And thank you to the audience, and thanks again to our panel. And the Attorney General will be here to provide a few closing remarks.
Well, there's a lot of information today, and I've been sitting back there listening all day. I have avoided the temptations to pull out any devices and check anything. I'm listening carefully to what has been happening today. I want to thank all of our panelists today. It was outstanding, and please give a round of applause to everyone who put so much work into that. And a lot of people at the Department of Justice helped put this together, and quickly. I promised to do an open government summit. I really had no idea we were going to get it done in July. This came together very quickly, and really two people are most responsible for that, though, the two youngest members of my executive team, Delaney Brewer and Johnny Coromeno. So thank you to them for incredible work. Now, sometimes it sounds easy. We tried at the Bureau of Commissioners of Public Lands to record a closed session. We've only had one closed session. That was to do it's not the annual review. It was the first review of the executive secretary in 11 years. So we did it in closed session, and we had this idea that we would just use the regular conference line. So we'd set that all up, and we'd begin the meeting in open session, then go into closed session, and that would be recording for us. And then it turned out, since we were all sitting in the room together and there was no one else on the line, it just kicked us out because there was only one caller on the conference. So it's going to take a little hit and miss to get stuff right, but we had the best of intentions that day. And I want to thank, too, the watchdogs, those especially in the media, but many in the public, too, who are watching and making sure that government does not slip the wrong direction in this. As someone, and I think it may have been Bill Leaders, I'm not positive about this, but someone said it's not only the public that is better when government is open, government is better when it's open, and I couldn't agree more. Is that you, Bill? Okay, thank you. I want to just kind of close off with a quote from a Wisconsin Law Review article that I didn't see until just a couple days ago. Never seen this before. The quote is, "Over the last 3 decades, statutes have not kept pace with technological advancements that have dramatically transformed public records, threatening the presumption of complete public access. Technology is butting heads with public records laws at all levels of government across the country." This is why we convened this gathering today. That quote came from a law review article written by Leanne Holcomb and James Isaac in the 2008 Wisconsin Law Review. It's 7 years ago that conversation was taking place. At that time, it goes on in the article to say that at that time, DOJ decided to wait until technology is better understood before requesting that the legislature update the statutes. From my perspective, if I wait until I understand all the technology, well, nothing's ever going to happen. The next steps. This isn't the end. we do plan after today to convene smaller groups to try to work on details to see if there are things that make sense. We will make sure that all of the stakeholders are represented as we do that. And we do welcome your feedback, as someone's offered before. Please get us that feedback today or in the future. And then finally, all of the materials that you've seen on the PowerPoints today will be available at the DOJ website soon, if not now already, very soon. So you'll be able to find those things there. And then finally, in closing, thank you to all of you for your interest in this important topic and your attendance today. Take care.